House Bill 185 as it is 11 o'clock. And we will review briefly what this bill actually does. It amends sections 2 and 3 of RSA 310-9. In one of the things I'm not a particular fan of is when you dive into something in the center and you don't look at the totality of a section. Totalities do sometimes give you a different perspective. So just looking at paragraph 1, which is not referenced in this legislation, but does matter. Part 1, which current law, which will not be changed under this proposal, states that misconduct brought within 5 years from the time the office reasonably could have discovered the act is in play. It also has that the board may consider licensee conduct without time limitation when the ultimate issue before the board involves a pattern of conduct that has occurred within the 5-year limitation period. So taking this bill on its face value, it makes it seem like there's a lot of rushing going on here. And I think it's a fair argument that could be made that maybe there is. But keeping in mind paragraph 1 is still matters. So again, reviewing this section, adding a 30-day time limit, the part A clarifying when this will make a recommendation to the board. One could argue that it's logical that they'd have to have a meeting to do it, but this just kind of clarifies that. And then, of course, section 3 gives them 90 days to complete the investigation. Now, one of the concerns when you add a timeline of this manner is the ability of the agency to conduct what you are asking them to conduct. And in this scenario, OPLC is saying we're going to need people in order to meet these timelines. Now, OPLC was created as an administrative function to get rid of duplication of administrative actions across boards. It was done to have consistency. It was done to provide a fair framework, and investigations is part of their scope. So we do have the OPLC's attorney with us. And if you would come up, I do have some questions in reference to just clarifying again the necessity of the increase in staff. I think there's logic to the request. I just want to get a little bit more clarity from you, if that's all right.
Good morning. Just for the record, Nicholas Fry, General Counsel with OPLC. So at the time the fiscal impact statement was written, what we did was we looked at numbers and how many cases we were reviewing, and then also how many complaints we were closing. So complaints that were coming in versus complaints closing. And so that's where we determined, based upon the staff that we have for the first fiscal note, that we would need double the staff. And then when the amendment was made, we looked at it and we said, okay, we have a little bit more time, so we'll take a few employees off of that.
Okay, so currently then, what is the number that you guys are asking for then now revised? What would you be? What is your necessity?
I don't have the fiscal impact statement directly in front of me. I can pull it up on my computer if you give me a moment.
Now, this is the one that we find here.
It should, hopefully you guys have the one in front of you that's tied to the amendment.
As amended, yep.
Yeah.
Yep. 0512 Senate amendment. Yep. Okay. Because in this, you're asking for 5 new investigation paralegals, 1 paralegal, and an off-schedule physician investigator for the Board of Medicine.
Correct.
So that's really 7 people.
Yes.
What do you currently run?
So we have, I believe we took two people off the original fiscal impact statement. So we don't have a physician investigator currently.
Okay.
So we'd either have to go to, we have a panel, physicians panel under the board statute, which is 329, or we have the board that we can go to, or we have experts that we can call. We have folks that are on call that we can call for that. But to handle that within 90 days and to fit that into that time frame, we would need a physician investigator physically present full time to be able to get through that load of cases.
Absolutely. Representative Grota.
Thank you. Thank you for being here, Attorney Fry. So perhaps you can, just so that we can get it all on the same page, you can share with us what the House Bill 655 did to the investigation responsibilities of OPLC. Let's start there.
Sure.
And the progress that has been made, because when this was all, one of the reasons why this was addressed was that boards should not do investigation and adjudication in situ, right? There needs to be two separate entities, one doing the investigation and then the other one doing the adjudication. And there were several public hearings about this. And because at the time I was the one who wrote the amendments for House Bill 655, and we did that based on the feedback that we had from the various boards and the agency, there was also at the time a significant backlog of work to do. So perhaps you can also address the improvements that you've made for that backlog, because it could be that, and I believe that Director Juris has talked about this before to us, and we're expecting a report from her in this fall, I believe, about the improvement, the continuing work that's being done to address the backlog. I realize that this question is very long, but you could just take us through that whole process. I think it would be beneficial. Thank you.
Sure. So I'll just give brief context on history, which is what I had done at the hearing. So obviously OPLC came into existence in statute in 2015, so it's relatively new agency in the grand scheme of things. The next major change would have been in 2021, which is when we went from having a dichotomy under OPLC of technical boards and the health professional boards to changing that dichotomy to a division of enforcement and a division of licensing and administration. Now, at that time in 2021, the boards still controlled licensing. They still controlled investigations and disciplinary proceedings fully. We were there for administrative and clerical services. In 2023, HB 655 passed, which is what Representative Grotto was mentioning, and that is what shifted. I mean, I always kind of think of it as like, right, we're going sort of from an Articles of Confederation to more of a federal constitution where there's centralized power. So OPLC now is in control of approving or denying licenses. The board set criteria for that. And with respect to investigations and hearings, the boards sit as decision makers or the judges, along with a presiding officer who is a lawyer that OPLC provides to them. So the lawyer sits there and makes legal conclusions, does the law stuff. The board sits there and makes factual determinations and participates with their subject matter expertise. So those folks together are what you have for a judge. You get the best of both worlds, someone that knows the law, someone that knows the subject matter expertise. With respect to investigations, as Representative Grotto was saying, that was set aside and isolated with the Division of Enforcement so that the boards are not getting directly involved with investigations, so that they can sit as that neutral fact finder at the hearing, right? none of us, if we were going into a criminal court, would want a police officer that's sitting, the police officer, let me correct myself, because there's a lot of good, I know folks that have become judges that were police officers, but we wouldn't want the police officer that charged us with a crime sitting as the judge, right? We wouldn't think that that would be a fair system. So what HB 655 did was sort of split up responsibilities among OPLC and the boards to try to have a more impartial adjudicatory system that mirrors more what you would see in a court setting, if that makes sense. So that's kind of the backdrop. And so to the next question, I know that some of, at least with Representative McGuire's concerns that she mentioned at the hearing is that she was getting consumer complaints about getting complainants, people that file complaints with OPLC or with the board as to status updates on hearings. So at the hearing, what I'd presented to the full committee was a packet of correspondence that gets sent out to both the complainants as well as to the person who's being investigated or the licensee. So the first, there should have been 20 that went out to you guys, but the first correspondence is an email that basically, in as plain a language as possible, says, hey, you filed a complaint. This is the process. This is how you might get informed. So when you file your complaint online, you're automatically getting that response back in an email to you. Then secondly, you get a follow-up correspondence, a letter mailed to you that says, hey, you filed a complaint and we've decided that this is a facially valid complaint. We'd like to schedule an interview with you. And then it again kind of outlines for you what the process is in as simple language as possible. So that's all come in with our new division director for enforcement, who started in November of 2024. So as Representative McGuire mentioned, this is stuff that's really happened over the last 6 months or so. So she has tried to, she's a criminal prosecutor, former criminal prosecutor. She's tried to make it customer friendly and also comport with the law, obviously. So we have those correspondence going out. Additionally, I brought some, there's also, with that correspondence, there was also the letter that would go out to the licensee letting them know the outcome of the complaint and that they'd like to get a response from you. So there's that letter. And then, of course, if your complaint is dismissed, our board administrator, right, who, because the boards dismiss complaints, would send out a letter on behalf of the board saying, hey, your complaint's been dismissed. And that would go out to the copy would go out to the complainant as well as to the licensee. In addition to all that stuff, I did bring copies. I probably bought way too many of them, but also of just, it's just print offs from our website. So you can see what our director's done there as well. So she's put up a letter explaining the process and what the purpose of enforcement is. So that's one of the web pages. You've also got, she set up a enforcement complaint process that has the various steps explained in as common language as possible. She worked with me on that before she put that up on the website. There's also a page for frequently asked questions. So you can look on there, should I file a complaint? Who can I file with? So she's kind of gone through and looked at the different types of questions that are coming into the Division of Enforcement through email and phone calls and tried to answer things that she can answer broadly on the website. So she's done that undertaking. And then I also included this. I know that this wasn't a concern of Representative McGuire's, but we've also done the same thing for our hearings bureau. So we've put up a hearings process guide for self-represented litigants to help walk them through the process. And I can tell you, as a former hearings officer, we also, the presiding officer takes the time, just like you all do when you're sitting in your chair, to try to explain things in as simple terms as possible to the folks that are sitting here and probably a little bit terrified, right? Because you're sitting in a hearing. So we try to help folks out that are self-represented as much as possible. And we've really tried to address those customer service complaints that were coming out.
So it sounds like OPLC, what you're offering, what your processes are, you've taken a ton of time to make this, as transparent, as simple as possible. And this bill doesn't question any of that, right? What this bill in essence does is it basically establishes a timeline for what might be called a probable cause hearing, right? 30 days to determine whether the allegation on its face has anything to it, okay? And then, of course, you have the 90 days to complete the investigation with another 60 days of time after to make a final determination. So 5 months in essence in the process. So the question here is back to your statement of this is what's coming in versus this is what we're processing out. And what I'm hearing is that if we establish these time restrictions, the amount of out is going to shrink,
Correct.
right? So with current staffing levels. So you're looking at and that's, I think, what this is really all about is the processing of in to get it out within the confines of newly established state law restrictions. So the question then is there's an answer provided here saying we need 7 positions, but there is also a potential another answer in the sense that is 30 days sounds like 30 days isn't reasonable. So do we have a timeline perhaps where there's the 30 and 90 days is more reasonable for your office to process these without having to hire 7 positions?
I think
where
that-
you might have to hire 2 positions.
Sure. So there's a couple things. I do want to give some context from the hearing that I haven't spoken to yet, and then I will directly answer that question.
Sure.
But so I agree with you. I think that is a central issue. But a secondary central issue is looking at the 5-year statute of limitations and considering how that is going to interplay with creating new timelines within RSA 310.9. So just a brief summary. And so the main concern, right, is you have a 5-year statute of limitations in the OPLC statute. In quotation marks, it starts off with allegations of professional misconduct shall be brought within 5 years from the time the office reasonably could have discovered the act, omission, or failure complained of. In most situations, in plain speak, that means when the board receives a complaint or OPLC receives a complaint, the office has or the board has 5 years from the time the office received that complaint to vote to initiate a disciplinary proceeding. So if you start creating timelines within that 5-year period, you have the potential for creating a conflict on that, right?
You don't
So
have a 5-year period.
you don't necessarily have one, right? So that brings me to the second potential statutory conflict. SB 185 as written would allow a board to dismiss before that 5-year limitation period simply because it thinks an investigation should have been fully completed, right? And so now we're taking out that public protection element potentially. A board has the ability to vote to dismiss something without really, they should be considering the public protection element, but there's no guarantee that that will happen, right? So if you look at the Board of Medicine or the Board of Nursing, they all have a statute that says the primary purpose of this board is to protect the public. So that could potentially lead to a situation where the board is asked to make a decision that's in direct conflict with their primary purpose. And then in addition to that, and probably a less significant conflict, statutory conflict would be that under RSA 310.9, the executive director has the ability to make rules on the investigative process. So in some ways, if you're putting a timeline in there, you're kind of undercutting her ability to potentially do that in the future if she saw a need to do that. So for example, and I brought this up at the hearing, the executive director had previously used her rulemaking authority to create a stricter timeline in the hearing setting. So under RSA 332G:8, once a board has voted to initiate a proceeding, it has 2 years to hold a hearing. So it's like your right to a speedy trial, essentially. And so what the executive director has said is that in the case of when you emergently suspend someone's license, in other words, you take it without holding a hearing, and you have your 10-day hearing, so that would be the process for an emergency hearing. You get your license taken away, then the board has a hearing in 10 days, then the board says, you're not getting back your license. That's a potential situation. So she's saying in that potential situation, if you don't get your license back at that 10-day hearing, the final disciplinary hearing on whether you've committed disciplinable conduct and whether the board should either revoke your license or take some other action must occur within 60 days. And there's a provision if there's still some investigation going on that could extend it out as far as 120 days. So the executive director has demonstrated that when she believes there's a need, she's willing to create rules that create a stricter time period. I guess in this particular case, given the fact that we've undertaken these, where's my big stack of paper, undertaken these efforts to try to give better customer service within the last 6 months, that is like the first policy step, right? A policy or procedure step. So we're starting at the lowest level. If that's not functioning, then moving to rulemaking. And then if that's really not functioning, I mean, the legislature is obviously here and they could rule on it. They could put forth a bill.
So in some ways, though, we've just gone right to step 3 here.
Yes.
So, yeah. Okay.
And Director Rogers, who's the division director of enforcement, is actively working on policies and procedures for her staff as well.
Right. And they've existed for
Less than 2 years.
Less than 2
And at the
years.
time the bill was
Yep.
filed, I don't know, maybe a year and a half.
year and a half. Yep. So this is my third term, my fourth term in the House, third term on ED&A, and it seemed this isn't new, and I don't mean this specifically. The impatience, I suppose, of not allowing OPLC to work through the fact that it's a very new agency, that it needs to tweak, it needs to adjust, right, based on consumer demand and the responsibility it has within the professions and the boards to be functional. And we are once again dipping into controlling aspects of this and not allowing OPLC to naturally progress. That's how I see this right now, right? Because
I am a father of young children and I hear what you're saying.
so I am not, but what I will notice here is that when you bring a concept forward to modify statute and all of a sudden it's going to require a staff of 7 that you don't have, that we don't have a budget for, nor do we have an appropriation for in this, you are not allowing OPLC to naturally, organically progress as an agency. Representative Garota.
Well, I'm also saying that in paragraph 3 on lines 15 to 18, if we say that the board has the discretion to instruct the office to discontinue the investigation, that is against the intent of separating the board from the decision-making process of the investigation. We've removed their authority to determine what will be investigated and what will not. And by putting this timeline on, you're basically unraveling all the work that was done on House Bill 655. And there was significant intent to do this. So I'm very concerned about this kind of language. And I agree with what you just said. You know, we're starting, this is new, we're starting. And let's see, I do believe that when the Director Juris was here in January, it's hard to believe it was just January, that she did mention she was going to give us an update as to where they were, because this is really for us when we implemented House Bill 655. This part was the most challenging part. This is basically the most challenging part that's left to be done, and I don't really want to right now, while this is an ongoing thing, set it off into another direction.
Thank you, Representative Grota. As you are a co-sponsor of this, I'm just wondering how this was sold to you to be a co-sponsor. Right? You can answer that? Okay, great. Okay. All right. So like I said, the only final question that I have for you is simply this. Is there a way to modify, if the insistence that this goes forward exists, is there a timeline modification to this 30 and 90 days that would exist for you guys to be able to pull this off with, say, 2 staff members instead of 7?
I mean, I guess it's possible if we push out the dates significantly. I'd have to look at the numbers and talk to that with the division director as well as Director Jurius. Like I said, my concerns though about creating time frame, as an attorney that's litigated a lot, one of my concerns is that creating conflicting time frames for limitations periods can create the potential for litigation. I can tell you, real estate appraisers boards had a statute with a similar limitation period back in, I think there was a Supreme Court case that came out in 2007 or 2008, where they had some limitation periods that were similar in terms of, like, you have to have the complaint reviewed by this time, or you have to have the investigation completed by this time. And the Supreme Court took a look at that, and that ended up getting litigated. So it cost the state money.
Well, we're looking at cost of state money right now with this.
Sure.
So I'm just trying to look, I don't have a problem necessarily spending money to make government work, but this seems a little self-imposed. Representative Bailey, jump in.
Well, I've heard in the past that the license fees cover the costs of these things. So is this coming out of the general fund, or is this coming out of license fees? This $750,000.
There's no indication at all how this will be handled. There's, in the fiscal note, it's all asterisks and blank. Sure.
So this is sort of a catch-22, because licensing fees are part of rulemaking, and then they go to GELCAR, and GELCAR is very concerned about the cost of licensing fees. So we have a tendency to be very strict about those. So it's a conversation that we had during this, and at the time, I wanted to speak about it with the committee when we talked about this bill again, but I don't see how this kind of cost can be covered by licensing fees.
Well, if it spans the dozens and dozens of licenses,
Yes, but note that not all boards are concerned about this process. This was brought forth by, if I believe, one board. And I don't know if they represent all the other boards that are part of OPLC.
well, for somebody not on GELCAR and not concerned about license fees, but rather a taxpayer is paying out of the general fund, it's like, do I care?
No, because if I'm not mistaken, by statute, the OPLC is a self-funded organization, so it has to generate its own fees. So the licensees would be paying for it. Well, I don't know. It's not here, but I would suspect so. But
We need to amend it to put it in there.
no,
I don't think you do, because
To prevent it from coming out of the general fund.
it's already in statute. Yeah, it's already in statute that they're self-funded. So, okay. Well, thank you for
Sure. So, I mean, I guess to I think what Representative Grota was getting at is there's the possibility that the statute could go through, but then the funding actually doesn't go through for jail car.
Kind of have to. We kind of have to. All right. Well, thank you. We have some other folks that definitely want to throw some input into this. So, but
Sure.
you've explained to me what my question was. So
May I
perfect.
just pass
Yeah,
out the
absolutely.
handouts? Thank you.
Yeah, absolutely.
So I do will make a comment about this. When this legislation was filed, I was asked to be a co-sponsor, and I was concerned about the kind of response that the people were getting, but I was unaware of all the work that had been done by OPLC. So that's
Gotcha.
the
Okay.
issue.
No, understood. I've been a co-sponsor to bills I have voted against. So I was just curious as to the background on that. So by all means. Oh yeah. Yep, I believe we do as that was part of the, yep.
Thank you very much.
Absolutely.
For taking my testimony. So
Who are
my name
you?
is Bob Quinn. I'm the CEO of the New Hampshire Association of Realtors.
Okay.
So the document in front of you, I know OPLC also provided to you. So that the document on top is provided to either licensees and consumers, sort of explaining the complaint process. And the letter at the very end is the one that is sent out when investigation process begins. So as you can see, there are really 3 steps here. Step 1 is intake and review. So I don't think there's any disagreement on this issue that corresponds to the 30-day requirement. I think OPLC has said that they can handle 30 days to take intake and review to ensure that there is some sort of professional misconduct at least cited in the complaint. And that is entirely an OPLC determination, and the bill wouldn't change anything on those lines. Step 2 is the investigation. Again, that is entirely under OPLC. The boards and commissions have no involvement with the investigation. I think with the very first item, you can see perhaps part of our concern and some other boards' concerns, where it says case assignment. So cases are assigned in order of priority, based first on matters of public safety, and second under the order in which they were received. We understand, and certainly don't have any quarrel with the fact that complaints that go to the medical board will take precedent over complaints that perhaps are real estate related. But what keeps happening is those complaints go to the bottom of the pile. So the Real Estate Commission just issued an order this past, about a month ago, I think it was now. So a case was filed in 2019, a complaint by a consumer. It went untouched for 5 years at OPLC, and you hit that statute of limitations. So even though there was potential professional misconduct, it had to be dismissed because it was never brought to the attention of the board. I just talked to I have a variety of stories. I talked to a broker yesterday, has an agent, received the letter in the fall of 2021 indicating a complaint had been filed, has heard absolutely nothing since. So we're going to be close to 3.5 years, has heard nothing. So that really gets to the notion of how do we ensure that boards and commissions are made aware of these situations? And that's the intent behind the bill. If it's not 90 days because of the fiscal note, 180, 365, whatever it might be, is going to be better than what it is right now. It is known out there among licensees, at least in real estate, that these take at minimum 18 months and sometimes several years to resolve. Oftentimes these complaints are not complicated. Probably the most common complaint is someone from Massachusetts who's licensed in Massachusetts, jumps across the border, is not licensed in New Hampshire, and engages in real estate, and then they jump back across. The Real Estate Commission is made up, and I think most of the boards and commissions are similar. They're made up with 5 individuals. One of them is a practicing real estate attorney, one of the larger firms in the state. We have a public member, and then we have 3 individuals who have engaged in real estate for decades. Oftentimes, what we used to see in those situations, the plaintiff and the defendant would be brought in. They would have an opportunity to present the information. Were you licensed? Were you not licensed? Demonstrate you were licensed. Oftentimes, it's clear they're not licensed. In those situations, if you go to step 3, which is the adjudication process, so that is entirely up to each board and commission. So the OPL, just as the board and commission is responsible for the adjudication process, just as OPLC, and there's no involvement with OPLC. Similarly, during the investigation process, that's just entirely up to the OPLC. We're just, if 90 days isn't the right number, whatever number gets to a fiscal note of 0, that's better than what it is right now. It at least ensures we're not going to have situations where complaints are 2 years, 3 years. I sympathize and recognize the challenges the OPC has, but everyone has to recognize that all of these boards and commissions were created to serve the consumer and to ensure that the consumer had an opportunity to file a complaint. If we're going to have rules, if we're going to have regulations, then there has to be some reasonable way to enforce them. And I think a lot of folks, when they see you're talking years away, they just decide it's not worth my hassle. So that's the intent behind it. There's more than one way of doing this. But we did want to bring this at least to the legislature's attention. Statute of limitations, as far as we're concerned, has to do with how long I have to file a complaint. It has nothing to do with the process that takes place with OPLC and the boards in terms of investigating and adjudicating the case. So we think those are kind of apples and oranges. Certainly respect the concerns that were raised, but that's kind of why we brought the bill forward in the first place, just to ensure a little bit more transparency. If the word, I think the word in the bill is complete the investigation. If there is some other language that could be used, where all we're asking for is for the OPLC to touch base with the board and the commission. We're suggesting it 90 days to inform them, here's where we are with this investigation. Here are the facts of the case that we have so far. And at that point, the board or commission can make the determination, you know what? We have enough information. We can bring these 2 parties in and we can adjudicate this case. Or they may make the decision, no, we don't have enough information, recognize that this one is one that's gone to the bottom of the pile and you haven't had a chance to get to it yet. And then it's given back to the OPLC. So I don't think it's interfering with the investigation. It's just informing the board or commission, do you have enough information to adjudicate?
So back to my previous statement about functionality, and I'm not, like I said, necessarily opposed to if OPLC in its infancy as a agency needs more people to do its job, so be it, right? And it sounds like maybe they're understaffed, and that happens. And I'm just, like I said, trying to figure out the reality of what these timelines meet. The 30-day thing initially, I agree with you. I think that's what's brought forward. You look at it, you've got merit or you don't, right? It's something's there or it's not. Or it's like, maybe we got to look, we're going to have to figure this out. So I suppose it's really more the 90-day part on line 15 that is concerning to me, where they are, like I said, the intake is exceeding the processing. So for you to bring forward, circumstances of something that was filed in 2019 that never got to is concerning. Certainly there's absolutely zero public protection going on in that case at all. And the idea that I know it's a competition of resources between the boards, right? As far as, like you said, Board of Medicine complaints, some really taking priority in some cases versus, something about what an electrician did that might or might not be a problem. So I guess that's really what, this committee is going to have to figure out here is moving this forward in a reasonable way that will address some of these concerns, keeping in mind that we have, members of the general court that are adamant about the limiting the growth of government here. So there's going to be a balance there.
And like I said, if it's 90 days, if it's 120 days, if it's 180, if it's 365 to get that down to zero, it's going to be better than it is today. And
Yeah, I
again,
agree.
in the language of we're happy to work on it and change, what we're asking for is in some way for the OPLC to touch base with the board and commission so that they're aware of these situations. And then I know that there's conversations that occur between the board and the OPLC. And there may be an opportunity at that point to have a conversation to say, hey, this is ripe for adjudication. We're comfortable where this is right now. And they, under 310.10, have the authority to do that. So that's really what we're trying to get at here, just trying to eliminate these. I mean, the other case of the broker I just mentioned, I mean, we're getting close to statute of limitations there as well. And there could be others that I'm just not even aware of at this point. But I don't think 5 years is a reasonable period of time for a consumer to assume that the state is going to act upon a consumer complaint, especially when a lot of these complaints, maybe not from the medical board, from something like the real estate commission, they're not highly sophisticated in terms of having to look at the facts of the case and the fact base.
The other concern that I have too is that when you get into a situation where it becomes readily known that complaints are not processed, the effectiveness of enforcement disappears because, well, I could get away with it. It's minor. They can't process it. 5 years goes away anyway. So,
And add on to that, it's I think what we're seeing out there is, and I can't speak for all, I obviously can't speak for consumers. I can just speak for the licensees. I think licensees are making the decision. I've seen something that is probably, or what I'm concerned is a violation of the Real Estate Practice Act. But do I want to dedicate 2-3 years to this? I do not.
Sure.
Whereas if they were to say, hey, 3, 4, 5 months, it's worth my time to do. We have an internal process, just an FYI, within the state association for something that's similar. Consumers and licensees can bring grievances. We have a code of ethics you have to adhere to. And we have very strict timelines of when that has to happen and processes. So it is all completed within 4 months. We're able to do it. And it isn't an undue burden. Now, we're not asking for the completion necessarily of a case. We're just, again, trying to get some way where the real estate commission, other boards and commissions are at least informed, notified, brought up to speed on cases and allow them to make the determination, okay, we can move this thing forward.
sure, go for it.
Thank you. So the letters that are sent by OPLC regarding complaints, does the board receive a copy of them? I'm looking at anybody because that could be a way of keeping people in the loop, right? You're sending out these letters, and if you're not, when you say, I'm having a hard time, Mr. Quinn, understanding, you're a member of the New Hampshire Realtors Association, right?
That's
But are you on the board?
Of the real estate commission?
Yes.
No.
Okay. So shouldn't there be somebody from the commission here that would be able to, because they're the ones who do the adjudication, correct?
I think we look at it from the perspective of we're trying to protect licensees and consumers.
Okay.
And we're trying to ensure the government is properly working. And I think that if we all were to acknowledge or accept the fact that a complaint that's filed that has risen to the level of that there's professional misconduct. 5 years later, no action is taken, therefore it's dismissed. I think that's a problem. Something needs to be done to resolve that.
Okay, I guess my concern is somewhere along the line, we need to loop the organization, the commission that is actually the organization that works with OPLC.
Sure. I mean, that's,
And so that's, you know, so, and the fact that they're not here is a concern to me.
I mean, I've been doing this for a number of years. I don't think I've ever seen anyone from the Real Estate Commission testify at the I could be wrong, but I don't recall that. And there may be, I think, I can't speak to whether or not they're allowed to either, in terms of the rules and regs, in terms of OPLC.
I don't believe the legislature is more than willing to hear from anybody. So if there was a restriction that existed, we would end that pretty fast.
Yep.
Yeah. We've defined a problem here. We clearly have one. So I guess the matter here is that how do we get to a solution that reaches a balance that we can find acceptable to move forward, is really what it all boils down to. And I think the full committee will have to duke that out, but it seems like the OPLC is understaffed. That's what I'm getting from this.
Yes, but my concern is the relationship that OPLC has is with the Real Estate Commission, not the Real Estate Association. So how does, it could be that whatever we're asking OPLC to do is going to be done with the commission, not with the association. So I'm just trying to figure out how that's going to address.
I can't speak for them other than that I've had conversations with them. I would be very surprised if any of the commissioners said that they would not welcome the opportunity to be provided cases to adjudicate. If you look at the cases that have been adjudicated at the Real Estate Commission, if you go back several years, 2019, 2018, 2017, you might find 25 cases a year being adjudicated. This year there were 2. Last year there were 2. So they're prepared. That's what they thought they were signing up for, I think, when they did this. I think the other issue is we recognize that OPLC is never going to be fully staffed, whatever that means. It's just the reality of the situation in terms of how much money is available across government. But remember, the reason why the Real Estate Commission was created to begin with was to adjudicate these cases, was to take the complaints and resolve them to some degree. And all we're trying to get back to is allowing them to do what they were created to do, which is adjudicate cases.
So the Representative Grota, the language of the Senate Bill 185, I mean, clearly this is all directed towards board, right? I mean, the board's mentioned multiple times. So, but I think when we have both the end user and the OPLC both acknowledging that they can't process the workload, the problem's been defined here. So it's just a matter of how we solve it. And Representative Bailey has it, you have a good point in the sense that it's internally funded. So from a taxpayer standpoint, right? Who cares? But we have to balance.
I assume there's other licenses that are not medical licensed that are also further down the chain.
Of course, there's 54 to 56 boards depending on who you talk
Yeah.
to. And sure, absolutely. I mean, this is a universal application. This is not
So it's
specific
not
to any
always just going
board.
to be doctors versus realtors. There must be plumbers and other people
Of course,
in between.
right.
that are-
This would apply to all boards,
yeah.
right? So that's where
And who it does not apply to is non-licensees.
well, non-licensed,
Might be time to raise the license fees
and that may be the and
to
again
hire these people.
that might be the answer here. So
And perhaps since all of these things were conglomerated recently under OPLC, perhaps they just haven't had a chance to figure that out yet.
Right. And that goes back to my comment about the organic
'Cause some of the-
progress of that agency.
I'm going to say 655 is less than 5 years old, where we're suddenly in danger of
Yeah, it's like 3 years
reaching
old.
statutes of limitations.
Yep.
It maybe this needs to move up in OPLC's priorities. Is how many complaints do we get across all the licenses, and what would it cost to investigate them all?
Right. Absolutely. Yeah, go for it.
So the other thing that's rumbling on in my mind is that there is a joint legislative committee on OPLC. I'm on that, but we've not met. So it should be something that we bring up, and it could be that it's something that can be managed through that organization as opposed to legislation. I can discuss it with Senator Carson I believe she was the chair last year, but it's something I can discuss with her.
Okay. Well, so as far as the subcommittee goes, I think we have a couple of different angles here to bring to the full committee, but I don't, as far as this piece of legislation and potential amendments or potential modifications here, I think really the concern involves the 90-day completion part. There doesn't seem to be concerns about the 30-day part at the beginning. Line 6 was assumed. I don't think that changes anything. So I guess it boils down to either one, do we take that 90-day and move it to something a little bit farther out? Or two, we kill the entire thing under the idea that OPLC will handle this internally. I think that's kind of what we're at here.
I agree, and I think the other option is to, excuse me, see if we can extend. What they did say was that they understand that completing the investigation within 90 days is unrealistic.
It's unrealistic. Yep.
So we don't have to. We can change this so that the office shall have 120 days to report to the board, for example, on the status, as opposed to, and it's something that I'd like to discuss with the director of OPLC, because we could. This is definitely the part that's and we strike that if the investigation is incomplete, the board has its own discretion. We strike that part of it because that's definitely. But if the subcommittee will allow, I can expand. I can come up with something for that line.
Well, like I said,
The 5-year statute of limitations, that's ridiculous. So
It
it has
is.
to be some period of time shorter than 5 years.
so in that particular case, Representative Bailey, an amendment to this would involve this piece of legislation currently touches paragraphs 2 and 3. You're talking about bringing in language on paragraph 1, which you're more than entitled to do, but that's the 5-year statute of limitations exists in paragraph 1 of 310. So I think we have a couple of concerns to bring forward to the full ED&A committee on this, for discussion during executive session, no doubt, right? I mean, between the 5-year limitations, the 90-day completion cycle, and then what that translates into information that is translated over to the particular board that is affected.
Okay, but why? I have to say, why is 5 years ridiculous? It could be that somebody has a criminal. It could be that somebody was killed. So I don't think that we should noodle around with that.
Well, hold on one second.
In
though.
terms of withdrawing their license,
Yeah, that's a license. We're talking about a license issue.
Oh,
not,
I see.
not sending them to prison.
that's ridiculous that we can't investigate whether their license should be withdrawn within 5 years.
Okay, so I'm writing down our 3 points here. So, statute of limitations at 5 years. The completion.
It's not Dr. Fibes. It's a realtor who's crossed their lines that they seem to be concerned with. 5 years to figure that out?
Well, their particular issue, but yeah, that translates into plumbing and electricians.
But it's
and
for
other
all
boards.
boards. It's
All
not just,
boards.
this
Yep.
is for all boards.
Even we're a doctor who's gone mad. It's Dr. Fibes. He's going to be operating for 5 years while we figure this out?
Okay, so the completion of 90 days is not reasonable, and you're talking about the discretion to dismiss, right? Is that what? Yep, the discretion to dismiss.
I'd like to reword line 15 to 16 and then eliminate the second half of 16 to 18. I'll noodle that out. And then you can look into the 5-year statute of limitation. How's that?
Okay.
Could it be the 5 years and the section that's not in the bill is irrelevant if we address the timelines in these other parts that are in the bill?
If you want to, because this is covering section 310, you can amend this to anything in 310 and
Yeah.
it's germane. That you're not opening a can with that. So if you want to address the 5-year statute of limitations that exists in paragraph 1 of RSA 310, you can.
Would it really matter if you make a determination within 120 days with the 5 years? I mean,
The 5 years though is not just about processing. The 5-year limitation also has to do with bringing forward a complaint.
oh, all right.
You see what I'm saying?
Yeah.
So something happened 3 years ago. You've been thinking about it, and you realize, holy cow, this was, they violated either their ethics standard or the law. I'm bringing this forward now.
Well, perhaps I'm out of order and complaining about that then.
Okay. I mean, that's the other part of the 5-year statute of limitations. There's two parts of it. It's one, bringing forward a complaint, and then two, processing a complaint. You can split that.
No, I'm just, what we're hearing here is though that got out to almost 5 years or 5 years and we haven't even had an investigation completed.
Sure. And I think that's why the push to have paragraph 3 modified to say you've got to complete this within.
Yeah, yeah.
Yep.
I'm sorry to have overcomplicated it.
No, not at all. Not at all. Okay. All right. So it sounds like we've got a couple of angles here to bring forward to the full committee in executive session and and potentially an amendment to correct some of that. So, all right. Well, there we have it. So if there's no other, okay. If there's no other testimony that would be brought forward and we're good with the discussion, I will close the subcommittee hearing on Senate Bill 185 then.
afternoon. It's having reached 1 o'clock. I'm opening the public hearing on Senate Bill 61, and I call Senator Gray.
Thank you. My name is James Gray. I am the represent Senate District 6, which starts up in Alton and Gilmanton, comes down Route 11 to Rochester and Stratford. I apologize for being out of breath, but I tried to get here on time, so there's people that I left in my office still talking. All right, there's actually two bills that talk about prescription drugs this year. And I was told that I couldn't do it in one because Health and Human Services controls one and the corrections system controls the other one. Sometimes, and I'll give you the same speech that I gave them, I like to save money, okay? I go to Hannaford, I shop, and when there's a store brand, I go buy the store brand. Unless I have a coupon, unless there's a sale, unless some other reason why it makes that generic, or I should say national brand, cheaper than the generic. And that's what's happening here in this bill. There are various programs that the drug manufacturers or others use that can actually reduce the price of the national brand and let me purchase it at a less expense than providing that generic. On the other side, the Health and Human Services, the estimate was $9 million that we were going to save. And believe me, I need that $9 million. They were going to put a different bill onto there also. But the total, because it's not just that, was, I was told it was $12 million. So this, I believe, is a common sense issue that let me do the same thing, for the state that I do in my own. And that is when I clip a coupon and I can get the other brand, for less expense, then I want to do it. And let me do that with drugs in the state.
Thank you, Senator. Are there any questions from the committee? No, seeing none. Thank you very much.
Thank you.
Ben Carbone and Jane Graham from the Department of Corrections.
Good afternoon, Madam Chair, members of the committee. My name is Jane Graham. I am the Strategic Communications Administrator for the Department of Corrections. And to my right is Ben Carbone, who is our Chief Pharmacist for the department. We would like to thank Senator Gray for sponsoring this bill on the department's behalf. The Department of Corrections is committed to providing safe, effective, and fiscally responsible healthcare to the inmates in our custody. This proposed legislation would enable us to enter into agreements with drug manufacturers and allow the utilization of name brand medications when it proves to be a more cost-effective option for the state. Additionally, this bill eliminates the outdated requirements for pharmacists to maintain handwritten notes in a patient's file when the brand name drug is deemed medically necessary, which aligns with the electronic record process that we have now. Allowing the department to directly negotiate with drug manufacturers provides the state with the opportunity to reduce pharmaceutical costs. While generic medications are typically more affordable, there are situations where manufacturers offer pricing incentives on name brand drugs that make them a more economical choice. Under the current restrictions, we are unable to capitalize on these savings, and this bill ensures our department can leverage all available pricing options, resulting in cost savings without compromising the quality of care. SB 61 supports fiscal responsibility, modernizes our healthcare practices, and ensures that we continue to provide high quality care to the individuals in our care and custody. And we respectfully ask the committee to vote to pass on this piece of legislation. We are both happy to take any questions that you may have.
Thank you. Representative Bland has a question.
Thank you, Madam Chair. Thank you very much. I'm sorry that I wasn't here when you introduced the bill, but when I saw what you put in, I saw exactly what you were trying to do, which is make sure that there's great care at better costs. My question is whether you would have a problem adding basically similar to generics on biologics would be biosimilars or interchangeable biological products. If you would be willing to look at also including those, because if anybody is on immunotherapy or any of the other large molecule drugs, I actually put together an amendment to get that language. That's what I was picking up.
Sure. So we would absolutely be interested in potentially adding that or leaving the current wording as is and acknowledging the fact that we do that already because biosimilars are separate of each other. So we can't necessarily generically swap them from a pharmacy perspective. But from that perspective, we also in the pharmacy review costs and make sure that we're using the most cost effective biosimilar that we can at the time that they're available. So
Follow up.
Follow up.
So it would not be necessary to add biosimilars in because you're already doing that. Is that correct?
correct. We already look for the most cost effective option in treatment at this point in time.
Okay. Thank you. I'll apologize to the trees that made these. Thank you very much.
Representative Schmidt.
Thank you, Madam Chair. So as someone who has used biologics in the past, I know that there are basically three ways of administering them. You would do it in the hospital. That's the most expensive. You get the same thing, but it's the most expensive. You can be, it's like half a mile away or something, as you know. The hospitals all have, or many of them have anyway, a separate facility. It has to be a certain distance away in order not to count as being done by the hospital itself. That's less expensive, but you have to be there to get it. Or you can have people who are not able physically, and that would certainly apply to your guests, shall we call them, where a specially trained nurse comes to the recipient and provides it at that person's residence in most cases. Are you guys set up for anything like that? Currently, without the cost advantages the business bill calls for. So can you speak to that?
Sure. Thank you for the question. So from our perspective, anything that we dispense as a pharmacy directly is administered in-house. So it's administered by DOC staff. Anything that is not allowed to be administered by us, it might be a special program drug or something along those lines that only has certain dispensing pharmacies. That might have to be a situation where we would send an individual out. But for the most part, what we would dispense at the DOC is administered by DOC staff.
Follow up.
Thank you, Madam Chair. So the thing is that you have to be specially trained, and as you know, you may know, the biologics have to be mixed on site at the time of dispensing because they have a shelf life that's considerably shorter, and they don't want to put them together until they're ready to put them into the person.
Yes,
So
Representative Schmidt.
so my question is whether your people have the training to be able to do that, or whether you could you have some place where the administrating nurse can come in and do it.
We at the DOC do not offer a compounding pharmacy per se for those biologics, so that would be something that would have to be administered off-site. A mixed component would be mixed up.
And you think that this bill would permit that?
I do think that this bill would permit us sending an individual to the outside to have that done, yes.
Okay, thank you.
Representative Darty.
Thank you, Madam Chair, and thank you for taking my question. Medicaid is deleted in a couple of points, and maybe you spoke to this already, but can you talk about why Medicaid references are deleted from the language?
Thank you. Apologize, I didn't bring that up to the desk. Thank you for the question.
It's on line 5 and line 15.
It looks like on line 5 there, sorry, it looks like line 3, it was deleted, and it was just including the Medicaid program. So I think they wanted to make sure that that was all included. But ultimately, the DOC doesn't deal directly with the Medicaid program. We supply all our medications direct from our in-house pharmacy.
Follow up.
So this is considered a cleanup? Is it? It just it
Yeah.
wasn't supposed to be there to begin with?
Yeah, this was a trial at cleaning up the some older language that may have been necessary many years ago that is no longer necessary.
Okay, thank you.
So do I understand you that, that your residents are covered with medically necessary drugs with, and do you bill Medicaid separately or what?
For medications, we don't bill Medicaid. We do have a process now in place for release medications that are going to go through the state of New Hampshire, but ultimately for billing purposes, we do not bill Medicaid.
So that the cost of maintaining an inmate includes the cost of medical care, including medications?
It does. When an individual is incarcerated, they are no longer eligible for Medicaid during their incarceration, with
no
some
wonder.
exceptions when they're in the hospital, but they're no longer covered. So that's all coming from us.
All right, thank you. That clarifies it. Any other questions? Representative Howard.
Thank you, Madam Chair, and thank you for taking my question. I'm just curious about a potential situation of of somebody not being able to get their required prescription in place of a cheaper alternative that is not necessarily the same compound. Is that something that may happen under this language?
This language wouldn't circumvent the Board of Pharmacy rules that require something to be a generic equivalent and AB rated in pharmacy. So ultimately, your biologics are a little bit different where they're bioequivalents, so we can't directly swap those. But anything that was an AB rated generic in pharmacy could be swapped between brand and generic manufacturers.
Okay, thank you.
Okay. Okay, any other questions? All right, seeing none, thank you.
Thank you.
Thank you.
Is there anyone else who wishes to testify on Senate Bill 61? All right, seeing none, I'll close the public hearing. All right. All right, I think we should go into executive session. Does someone have a motion on Senate Bill 61?
I'll move auto pass on Senate Bill 61.
I'll second.
All right. Do you wish to speak to your motion?
I actually don't. I think it's pretty self-evident.
Okay, thank you, Representative Lamb.
Thank you. I think it's pretty straightforward, and it seems that my biosimilar part was not needed, so it's much more straightforward than I realized.
All right. Anyone else have a comment? I'd like to say that not having to have a note in the pharmacist's own handwriting is probably a good safety precaution, because most pharmacists I've known have really bad handwriting. Representative Sytek.
Whoever, Representative Grota, be prepared. This has this feeling to me that you could get a lot of questions from the floor. So just be bulletproof.
Thank you, Representative Sytek.
Just a thought.
Representative Schmidt.
Thank you, Madam Chair. So I take it you all heard that the response to my questioning was basically that sounds like they would have to take the person out of the slammer and bring them to another facility. They couldn't, doesn't sound like they want to do it there. So I don't think it's a problem if the committee agrees, but
Well, I think that's, from what they said, that's current practice, and this wouldn't change
is.
it.
I agree. It's not anything particularly different. It's just they wouldn't be doing it there.
Yes. Representative Lamb.
Thank you, Madam Chair. I'd actually like to correct something on the biologic products. It's not a matter of compounding them. These are products that are grown in a cell instead of made chemically. So instead of being a small molecule drug like aspirin, these are actually grown in cells, and that's what makes them a biologic. So they don't need to be compounded on site. They're administered. They're already made by the manufacturer. So I understand you're talking about a different class of drugs, but what I was referring to were ones that already come fully formed, ready to go. They don't need to be compounded at the time of administration.
I'm not saying that there are not such products out there, but the specific kind of product I'm talking about needs to be mixed on site.
Yes. All right. Anyone else have a comment? All right. Seeing none, the motion is ought to pass on Senate Bill 61. And the clerk can call the roll.
Vice Chairman Leon,
Yes.
clerk votes yes. Representative Pearson,
Yes.
Representative Bailey,
Aye.
Representative Sheehan,
Yes.
Representative Slotchie,
Yes.
Representative Grote,
Yes.
Representative Schmidt,
Yes.
Representative Davis,
Yes.
Representative Dargy,
Yes.
Representative Howard,
Yes.
Representative Reese.
Yes.
The chair,
Yes.
13-0.
Okay. Does anyone, motion passes? Does anyone object to consent? All right, we'll put this one on consent. And I want to thank everybody for their efforts last week. We only have a couple of bills that we've heard that we haven't voted on. And I'm planning to schedule our final exec on May 21st, which is a week before the deadline. And so any bills that go to subcommittee or that we need to work on some more will be exec then. That's also the day before we're supposed to clean out our offices, so we'll all have a chance to do so. And we'll do that here in 15 minutes. All right. The two bills that we didn't vote on were Senate Bill 182 and 185. Does anyone wish to talk about either of them? Representative Lamb?
Thank you, Madam Chair. Senate Bill 182 seemed pretty straightforward when it came to us, but as I was digging into it, just looking at some of the details, there's actually some pretty substantial changes in there. It right now it works with the Northern New England Perinatal Information. And that is a group that's made from the two large academic medical centers up here, University of Vermont Medical Center and Dartmouth Hitchcock. Right now, the New Hampshire one that they look to change the designation from working with the Northern New England to the New Hampshire is a subsidiary within the Northern New England one, but that would be severing all ties with the academic medical center when we are talking about essentially a retrospective clinical study of all women who have been pregnant up to a year after they have finished their pregnancy, however the outcome. And that's something that needs a proper data handling and really should not be divorced from an academic center. So I'm very concerned with moving that away from the Northern New England perinatal information system. I'm also very concerned that this actually could be very expensive because it removes the prohibition, the language that says that nobody will be paid for being on this commission. That's something that's generally very standard with these panels and with a lot of these citizen and interest type legislatively created committees. But by removing the part that says that people are not going to be paid for serving on this actually could have a tremendously large cost to the state. And I'm very concerned about that. Additionally, sorry, I'm trying to find where my notes were. I was bouncing from place to place today, so I apologize. I did not title my documents well. Let's see. It also really expands the scope of the mortality review. We talked about only the pregnancy-related category, but there's actually two others in the definitions. They're pregnancy-associated death and pregnancy-associated but not pregnancy-related categories. Both of those would catch the accidental or incidental deaths that are being added to the definition of pregnancy-related. If you care about data, you should care about the validity of that data over time. And changing the definition means that we won't be able to compare the maternal mortality rates prior to the date of enactment with the maternal mortality rates afterwards because the definition has changed. Additionally, that also opens it up so that this partnership between a non-academic center, Dartmouth Health would be operating this along with the commissioner, would be reviewing all of the personal medical records, identifiable medical records of every woman who died, including the accidental and incidental, not just those that have a medical. And it strikes the limitation that only the personally identifiable information is made available to them when there's a public health threat. That is a massive expansion of invasion of privacy to women. I'm not sure that anybody here wants to have the commissioner and others going through a woman who had an abortion and then died's medical records and having that be de-anonymized and have their personal information there. Because that's what's going to happen, because within this, the definition is any cause, and in the statute it says including intentionally terminated pregnancies. So there's a lot to unpack on this. I don't think we're ready to work on to vote on this. I'll come together with something just a little bit more of a bullet list if I think that there's a way to make some of these changes, or if I think that this is going to be too invasive. But I've seen a lot of really big red flags, and I think that while we all look at an issue from different perspectives, I think all of us probably have some pretty big questions on that bill.
All right, everyone's looking sufficiently baffled, so we will not vote on that. And all right, in that case, we will take a break for a few minutes. Oh, sorry. What? Forgive me. House Bill 180, Senate Bill 185.
Senate Bill 185, which is the subcommittee that we had this morning. And I'm looking at Representative Pearson. I know.
Thank you for looking at me.
You're welcome. So, this is the bill that talked about the timetable for complaint management. And when we discussed it with OPLC, we discussed it with the New Hampshire Realtors Association. It became clear to us that the language in the bill, whether it was I think it was unintentional, conflicted with the language in House Bill 655 and the legislative intent to keep adjudication and investigation separate. Because it does, in the bill, it says that if the investigation is incomplete, the board, at its own discretion, can either instruct the office to continue or make a final determination, and it's not theirs to make. So they understand that, and at the end of the day, there was really only one part of the bill that was, that's already being done, and this what the expectations are of this bill could not be done unless OPLC hired 5 to 7 more people, which is not something that we are interested in doing, and it's certainly not something we can capture with costs of licensing. So I think our recommendation is to either retain it or deem it inexpedient to legislate. And I'll let Representative Pearson comment on that. Oh, no, since I'm not the chair, I can't let anybody do anything. I'm going to stop talking.
Who else was at the subcommittee meeting this morning besides Representative Pearson?
Representative Bailey was there as well. We looked at a couple things. You know, one of the things about this, not this in particular, but in general, is, you know, this starts off amending paragraph number 2. So what's paragraph 1 say? Right? Because if we're looking at a totality of a section, and basically paragraph 1 talks about a 5-year statute of limitations that exists, both to bring forward a complaint and to process a complaint. Now, the concerns that exist around that is 5 years is an atrocious amount of time for that office to have a statute of limitations, right? The purpose of the OPLC was to facilitate and process in a more efficient and effective manner. which 5 years is neither. So what it boiled down to was a couple of things. The first one being the fact that OPLC is a relatively young agency, and that this organization has to organically develop and grow as a state agency to meet the needs of both the public and the boards and its intent. And the problem is since OPLC was created, the legislature has lacked patience in allowing this agency to develop. We seem to love to put in bills to modify or dictate things to them that aren't necessarily happening in due time. The OPLC has made extensive amounts of progress in the way they handle these things. We all had handouts showing the various things that happen. And the reality is that it came down to this: input versus output. So the complaints that are coming in faster than they're being processed. As it is, they have a little bit of a backlog. There is some discussion as to whether that backlog can be, once it's handled, can we move forward as we exist? But taking this piece of legislation and now putting further time constraints on it, the 30-day part, it's really more like a probable cause hearings. They didn't seem to have an issue with that. But to completely process an investigation out to the board in 90 days is impossible right now. So looking at an increase of 7 staff members at a almost $1 million cost is substantial. Now, keep in mind, the OPLC is a self-funded organization. So now we're talking about fee increases to cover this. One of these requested positions is specific to a board, one specific board. So the folks in that universe are going to have to bear the cost with increased fees for that. So it comes down to basically, can the OPLC function with this legislation, with these constraints? And it's pretty clear that the answer is no, they cannot. So we have to make a choice. Do we agree to bring on more staff to handle this with a substantial fee increase within that universe? Or do we look at this timeline and say, okay, is there a more reasonable amount of time available, which OPLC basically said not really as of right now? Or we just hold off on this and allow the OPLC to continue to process the way it operates under its rules and under the authority of the executive director to work through this and have a little bit of patience with the backlog. That's kind of where we are with options. So as of right now, where they have been working through this for the past 10 months, I think if we were to bring on additional staff to handle that workload, we would have to be prepared to get rid of them after. So where are we balancing here? And I think that probably the best thing right now would be to just wait. Let's just wait a little bit, with the exception of one aspect, and that is within the Board of Medicine. That necessity appears to be kind of pressing. So keep in mind that this, we did get 2 different boards that kind of had an issue with this, but this language applies to all boards, not just the realtors or the Board of Medicine. This would apply to all 56 boards. So with a competition for resources, and where some of these other boards have felt like they're pushed to the back because as these complaints are brought forward, they are triaged in the sense of, the urgent matters are taken up initially, and some of the less ones get to the bottom of the pile. We're now learning that some of these complaints have existed to the statute of limitations and have simply just expired. So that's not going to work. So the question really is, how do we solve this problem right now? And that's what we're bringing to the full committee here, is what are we willing to accept as a solution to this, trading off fee increases for staff increases for time lines projected in this bill.
Thank you. That's a very interesting synopsis. Representative Seitek, you have a question, comment?
I think I have a comment that might be pretty obvious. If you're saying that the rate of complaints coming in, particularly to the Board of Medicine, are more than they can handle, then you're talking about letting this organization mature. It's going to mature. How can it ever get ahead of the game? Where I'm going is we don't hear a whisper. I'm speaking particularly about the Board of Medicine because I think that's more critical than real estate. You get hosed on the house. That's, you can repair that sort of, but not so much with malpractice, or I'll call it malpractice. Where I'm going is we don't hear a whisper about the cost of malpractice insurance going up. Why should we hear a whisper about our fees having to go up to provide public protection? And you're talking about what are you going to do with the 7 people? Well, maybe we could do 3.5 people and raise the fee. That's what I'm gleaning from the remarks that I have heard so far. And tell me why I'm all wet if I am.
Please.
So you might remember that when Director Juris came to speak with us at the beginning of the term, she specifically talked about complaints, and that because they had taken on this responsibility, there was a backlog. But they had a plan to work through the backlog, and we're doing that, and we're supposed to be giving us an update in September, which is why I didn't want to do anything specific about their protocol until we had more information on that.
Fair enough.
Representative Leon?
Thank you, Madam Chair. And additionally, we had a subcommittee working. We initially had a subcommittee working on some of the issues around the Board of Medicine. There were some changes in their processes that happened that they're still working through. So it might be a little bit more premature, but I do know as much as Senator Prentice probably wants a break from the room over there that I was in all morning. We probably maybe should wait until after, now that we've reached the time of the bill. I'll defer any further comments if we wanted to break.
Okay, Representative Seitek?
I think you're optimistic, that's all.
We always try to think the best of everyone. All right, we will all continue to think on that bill. Come out of executive session. I'll open the hearing on Senate Bill 172, and I call Senator Prentice. And I hope it won't take 20 minutes to explain to us.
The choice of chairs. Newer, more comfortable one. Good afternoon. Chair McGuire and members of House Executive Departments and Administration. For the record, my name is Sue Prentice. I'm the state senator from District 5, responsible for covering and responsible for 15 communities, largely Upper Valley, a little bit of Sullivan County, and 1 in Merrimack County, the beautiful town of New London. So I am here today to introduce to you Senate Bill 172 on behalf of the nurse practitioner community. And I want to open my testimony with just a very brief reminder or setting, or dealing with the context here, that our nurse practitioners are part of our primary care provider community. And our primary care providers are what I call the triage or the traffic cops for healthcare in this state, where you have to have a PCP in order to get a referral for more specialized care. When we have a bottleneck there, we have difficulty. So I'm always comfortable working in this zone, trying to remove barriers as well as work in a way for them that creates as much clarity as possible in law for them to be able to do their jobs. And that's what brings me here today. So as it stands right now, if you are a nurse practitioner in this state, which we call APRNs, you have to carry 2 licenses. One is an RN and one is a nurse practitioner. Non-compete, having a non-compete provision, this is what we're trying to prohibit, that is protected for the licensed RNs. but there's no language specific to this. There's an ambiguity for the APRNs. So what we're trying to make sure is this nurse practitioner who has to carry these 2 licenses, who has protection from a non-compete on their RN license, has the same for their nurse practitioner license. So that is, I'm always hesitant to say that something is really simple and it's just a technical fix, because usually it means it's a lot more than that. But that is ultimately what I'm working to do here, is to just provide that equity across and, well, no, really clarity, and remove any ambiguity for our nurse practitioners. So the non-competes, oh, sorry, I'll stop right there with my comments, my opening comments. Chair McGuire, I'm happy to take any questions.
Okay, we have plenty of questions. Representative Pearson and then Schmidt.
Thank you, Madam Chair. Yeah, I know, we're poorly placed speaker.
So I'm
So-
always looking around it.
Looking at any contract or agreement which creates, this is line 5, creates or establishes the terms of employment. That's a little bit different than a non-compete clause. So my concern is that in some cases, I mean, we have contracts that involve nurses in their employment, but that doesn't necessarily mean that that includes a non-compete clause. So are we abolishing employment contracts holistically?
Are you good? Thank you for your question, Representative Pearson. And yes, it is a poorly placed speaker. I find myself looking around it. No, we're not. We're it's not uncommon as a term of employment to have a non-compete provision. In my full-time job, I have a non-compete provision. What we're asking for here, and is already on the nursing side, they're prohibited. They do not have the law prohibits it. Actually, the Federal Trade Commission has reached into this pocket as well. We're just looking to take that and provide the same coverage for the nurse practitioners. We're not trying to, so it is essentially, it could be part of employment, but not here in this state. They can't do it for nurses. We want to make it for the nurse practitioners because that nurse practitioner carries 2 licenses.
Follow up.
That's great, and you explained it extremely well, but how come it doesn't read that way?
Provided, however, that nothing herein shall render void or unenforceable the remaining provisions of any such contract. That's line 11 and 12.
Mm-hmm.
So that says it's only the specific non-compete that's an issue. At least that's the way I see it, but I'm not a lawyer.
I'm trying to wrap my brain around the part where this is exclusive to non-compete and not more broadly applied to, because it establishes the terms of a partnership, employment, or any other form of professional relationship.
Shall be void and unenforceable with respect to said provision, provided that nothing. So it seems pretty narrowly focused to me.
Okay.
I could be wrong.
Okay. All right.
Representative Schmidt, and then Saito.
Thank you, Madam Chair. Well, this situation, I think, cannot be unique to New Hampshire. How has it been resolved in other states which have a similar legal situation as we do? Because how long has this been this way? And it has to have been causing problems the whole time. So I'm wondering what you know about this, since you clearly have looked into it, Senator.
Thank you, Representative Schmidt. And I cannot speak to other states. I would leave that. Is Kim Mohan with us today? Kim from the Nurse Practitioners Association would be able to focus in on that. But what I will offer to you is, I think I think we all know that the practice of medicine is just that, the practice of medicine. And we've seen evolution in nursing to nurse practitioners. physicians to physician's assistants, EMTs to paramedics, and each time we have to examine those and then go back and continuously examine to make sure the proper protections are in place all around for our patients and for those providing care.
Okay, Representative Sysak?
Thank you.
I'm not positive of this. I'm certain, my daughter is an APRN in Connecticut.
Oh,
She
okay.
carries one license, as far as I know. We've had a lot of Thanksgiving dinners. I always ask her about her hours, always. Well, you
good,
have
yeah.
to worry about that.
No, I know.
And she's never whispered RN. Why are we doing this at all? Why don't we just abolish the requirement for an APRN to be an RN also? That's past that. And if they're one, they're the other. They've had to go through that step. So isn't the whole RN licensure redundant, excessive in terms if you're an APRN? So I'm asking a little broader question.
No, I Representative Sytek, I appreciate your question, and I do want to leave that to the nurse practitioners to address. I understand exactly your point. It may just be that the evolution of this went from one to the other, and we haven't just consolidated this into one license. Some states, that's their prerogative. They are like, it's just one license. There's a reason that I'm not aware of in the history of this that I'm hoping the folks behind me can shed light on, but I think it's a great question. Thank you. Yeah.
I was going to ask the same thing. Representative Schmidt, you have another question?
Well, I want to follow up on this colloquy that we're engaged in right now, and that is, did these questions come up in the Senate? And if so, or if they didn't, then obviously you didn't have a discussion on it. But if they came up in the Senate, what insights did you glean from that discussion?
Thank you, Representative Schmidt. These questions, as far as when I was offering introducing the bill, did not come up in the Senate. I did have to leave, and Kim Mohan was there, but it's not reflected in the hearing report, so.
We'll ask Ms. Mohan to report
Yes.
on it. Since
Thank you, Representative Schmidt. Thank you, Chair McGuire.
All right, thank you. Any other questions for the senator? All right, thank you very much.
Thank you. I would normally stay, but I've got to go exec some bills in education. Thank you.
Good luck to you. Ms. Mohan, since we've got the questions lined up for you. Ooh. That's not on. There you
Good
go.
morning. Our plan was to submit written testimony on the website and to use our time today just to answer any questions that you may have. I do want to take a second and give you a little bit of an orientation to the handout that's coming around.
Okay.
Senator Prentice mentioned nurse practitioners being a huge component to our primary care workforce in New Hampshire, and indeed they are. I do want to make sure that everybody here understands that this bill, as it is proposed, would cover all APRNs, so all advanced practice registered nurses. That includes the CRNAs that provide important services here in New Hampshire, the midwives, and the certified nurse specialists as well. So it's a little bit broader than just our nurse practitioner primary care providers. I just wanted to be clear about that. But if you have any questions on the handout or on the bill, happy to answer them.
Well, the real question was, do you know why such a practitioner would need 2 licenses? Because we normally only need, we would only want them to have 1.
Well, I don't have an answer to that. I know that my members hold 2 because that's what the statute requires them to do, but I don't know why that happened. I would love to see, and I'm sure that my membership would love to see that changed. One thing that we would want to always make clear, though, is that APRNs are nurses and practice nursing at an advanced level. So that tie to the RN degree is really important because they belong under the Board of Nursing and being governed by the Board of Nursing. And we would not want to see that be jeopardized in any way.
Well, we would agree, but I think that it makes perfect sense to say that you have to have qualified for an RN. But once you get the APRN, you don't need to keep it up. It's like we just had a bill about nursing students working as an LNA. They certainly don't need to keep up their LNA license when they get their nurse license.
We would love to work on that, and if that's something that would need to come through the legislature next year, I'd be happy to
We'd love
work
to.
on that. That would be
Good.
amazing.
We will talk about it then, because I think the committee is in agreement. Representative Rees and then
Madam
Schmidt.
Chair, is it possible for us to amend this bill to get that done?
Yes. One would think that you would need to do this work now and develop an amendment that resolves that double licensing duty. Representative Pearson.
Well, the only thing with that, and I agree, I think that we've stumbled upon something that is, once again, in need of modification. I think to do that, we should hold a hearing on that
Yes, I would.
because of the magnitude of what the change would be to make sure that we.
That can certainly be arranged.
Yep.
Fine. We will not vote on this bill today. Representative Rees, if you have our full support in developing such an amendment.
That's the mistake of opening your mouth.
Make sure that amendment includes the non-compete provision.
Yes. Thank you very much. I'll do that.
Yes, it's not a total replace. We support that. Representative Leon.
Thank you, Madam Chair. I actually pulled up the non-compete on the registered nurses, and it's the exact same language, except it adds the words advanced practice read into the nurses.
And
So it's the exact, so is it your understanding that it's the same language that they already have under
it
the
is.
RN
It's
nice
the
license?
same language that probably intent covers them. However, when we asked the Board of Nursing for clarification before we put the proposed bill forward, we were told that they couldn't really guarantee that it would apply to APRNs because it didn't specifically say that. So that is exactly why we came and we have the language mirrors what is there for RNs. And I believe I have a colleague in the back checking right now. I believe it is the same exact language that applies to physicians and others.
Thank you. Follow up.
Thank you. And as a follow-up, even if we were not to move to a single license instead of two, do you believe it would be a good step forward to at least establish that non-compete for APRNs before we look at consolidating licenses, or at the same time? if we
Yes,
take that?
yes, I think that one issue is a housekeeping measure that just needs clarity in the language, and I think the other one might warrant a larger conversation, and maybe does belong in a separate space.
Okay. Well, if we could trouble you to talk to Representative Rees about it, we will see if we can deal with it this month. And next month, if we can't, we'll just go forward with this. Representative Grote.
So I have a question. It's probably not related to the bill, but it is related to this document. You say here that the APRN workforce is expected to decrease by 20% in the next 5 years.
Yes.
Follow up?
Follow up.
And why might that happen?
So we're seeing that across most health professions data research that's coming out of the health professions data surveys. A lot of that has to do with the number of providers who are retiring and the pipelines for bringing in new providers. I know that I believe that you guys have already had the bill come before you that has a lot of the workforce in it, and introducing young New Hampshire residents and students to the importance of the healthcare workforce professions, and then really the investments that we can make here in New Hampshire to grow our own and keep our providers here. But it's really not any different than what we're seeing in some of those other professions.
Thank you.
All right. Representative Schmidt.
Thank you, Madam Chair. So you heard other issues we were wrestling with when Senator Prentice was in the hot seat there. Would you care to weigh in on those discussions, whether we got anywhere or whether we have unanswered questions remaining in those areas?
Sure. I feel like we got everything covered. I don't know if there's specific loose ends here. I think we clarified that the language has been lifted from other statute, and that it has worked for nurses and physicians and others for quite a long time. I think we covered the RN, APRN license question. Was there anything else that was hanging?
Those were the main issues that were brought up.
Okay.
except for the question why the Senate didn't do anything about it. But which is, of course, beyond your knowledge. All right. Any other questions? Thank you very much. Brian Chiricello.
The Honorable.
Thank you, Madam Chair and committee members, EDNA. For the record, my name is Brian Chiricello, former state rep from 2010 to 2020, former county commissioner of Rockingham County. I wanted to express my thoughts of supporting this bill. I believe that the restrictions that are put on our nurses are enforceable. So I don't believe they really should be in there to begin with, but I believe that some of these nurses will sign contracts with them in it. I just wanted to give you, as a chair of the county commissioner of Rockingham County for 2 years, we had the second largest nursing home in the state. And at the time, when I was elected, was the COVID period, and a lot of nurses had retired because they just didn't want to deal with COVID and didn't want to deal with nursing homes. I can tell you firsthand that the county actually had 12 traveling nurse contracts, and that was quite a lot, costing the taxpayers millions and millions of dollars. But the interesting thing is when I talked to some of these traveling nurses, they had contracts as well that had non-competes. And we would have nurses that came from out of state that worked at the county that actually absolutely loved working at the county and wanted to work at the county, but they didn't because they had these non-competes. We all know collectively that the state's been talking about the shortage of nurses for the last 10 years, and we are starting to make movements there. What some people may not know is that we're starting to have a shortage of physicians. So the healthcare industry is, having them sign contracts with non-competes is not practical. So I just wanted to share that with you. I don't believe that they should be, these non-competes should be in these contracts. And if you can do away with it, that'd be great. The other thing I want to point out was that New Hampshire is the second oldest by age behind Maine. So we're all getting a little bit older, and healthcare is very important. We have a good healthcare system here, but dealing with shortages is not something that we should be playing around with. So with that, I'll end my testimony. Any questions, I'm happy to answer.
All right, thank you, Representative Sitek. And then.
Are you saying that other jurisdictions, other states have non-compete agreements with their nurses?
My understanding, doing some research, is it's really unenforceable. The FTC has ruled some of these as unenforceable. Personally, non-competes, this is my opinion, are for companies that have proprietary information where if I, for instance, if I created specialized software and a company bought me out but wanted me to work for a year to show them the ins and outs of the company, I would sign a non-compete, right? Because I don't want to compete against them. That's where non-competes are. In the healthcare industry, I don't understand why you would actually have them in there. It doesn't make any sense. Healthcare is healthcare, whether I work here as a nurse or here as a nurse, it really shouldn't matter.
Follow up?
I just want to appreciate your reading my mind. Thank you.
Okay, thank you.
Okay. Representative Reese?
Thank you, Madam Chair. I'm a little concerned that I may be arguing against myself right now because I went into this thinking, yes, non-competes banning the non-competes for APRN sounds like a really good thing. But then you mentioned 12 different contracts for the Rockingham County Nursing Home. And so if we do eliminate the non-competes for APRNs, may that affect whether or not some traveling nurse programs are willing to send people into the state of New Hampshire where we have a growing shortage of nurses?
I don't know if I fully understand the question. What I can tell you is they're already here in force. As I mentioned, when COVID hit, if you can kind of think back to 2019, a lot of us didn't know exactly what COVID was all about. That affected the nursing staffs in a lot of places where a lot of nurses just retired. They didn't want to deal with it, especially in nursing homes, because we were watching Italy, and we were watching nursing home where the people were passing away quite often. So a lot of nurses just didn't want to specifically work in nursing homes per se. So, running the second largest in the state, we had elderly we needed to take care of. So we had to do what we had to do. But I can tell you, it was at a huge cost to the taxpayers, millions and millions of dollars, because we actually had to we had federal requirements that we had to have staff. So
Follow up. So I think I didn't express myself sufficiently.
I'm
clearly.
sorry.
So my question has to do with, if we pass this, if this gets signed into law, then is the function, or is the effect of that, say, for example, I provide traveling nurses. I'm a business, a for-profit business. I'm based in Maryland, and there's an acute need across the country, and especially here where we're second oldest only to the state of Maine. So we have problems in finding nurses for our nursing homes. If we pass this, does it disincentivize out-of-state companies from sending nurses here? And I'm not talking about the back end of, well, send them here and then we'll scoop them up because
right,
the
I
non-compete
understand.
is gone. I'm talking about the profit driver for them. If they're thinking to themselves, we recruit these people, we train them, we do whatever, we get them licensed in the States, we ship them off, we provide the housing, the per diems, all of that. Then New Hampshire, because they have this rule, they have a law against non-competes, the New Hampshire is going to gobble them up. So in fact, we'll choose to send them to Maine and New York and Texas and all these other places first, and not to New Hampshire, which may then build upon our problem.
Yeah.
Maybe that is
No, I
me
see
asking
what-
you to get out over your skis in terms of.
Yeah, I see what your question is. I
you.
don't, but first off, I want to preface this by saying I don't blame anybody for wanting to better than themselves. So I'm not pointing fingers at traveling nurses. I think that they do a wonderful job. If you can make more money, you can make more money. My understanding of traveling nurses is all about the money. There's typically no benefits. I had two M&As at the county that wanted to work. After they worked in the county, they actually enjoyed it. And they were traveling from state to state, making their money. And they said, it would be nice to work here, but they couldn't. They could not work at Rockingham County because of the compete contract.
Excuse me, didn't we hear that a registered nurse can't have a non-compete agreement?
Yeah, so I have many different types of nurses at the county. So I think I just made a blanket comment overall
Okay.
about the topic of non-competes.
Forgive me. Representative Schmidt, you had a question, and then Saita.
Thank you, Madam Chair. So, Brian, you mentioned in your testimony that the Federal Trade Commission, I think you said, has kind of ruled these non-compete clauses unenforceable. So, can you speak a little bit more to that? I mean, because if they've struck them down, then that's the fact.
Yeah.
They're not enforceable, and therefore it's kind of a non-issue, isn't it?
Right. Thank you, Representative, for the question. I'm not an expert in the field. My opinion is FTC has ruled on these, and if someone actually took them to court, they would be ruled unenforceable. The problem is a lot of people sign contracts and then they feel that they're being held by a contract. They may not understand that, and they may not want to fight it. So that's the problem. I think if you just do away with it, it's be cleaner, and then people can work where they want to work. I believe in free society.
Thank you. Representative Saita, you had a question?
Yes, I do. How can non-comp is a private agreement? If somebody comes from Maryland and has signed some kind of blanket non-comp, our state law can't affect that, can it?
I'm not an attorney, so I wouldn't, I wouldn't know how to answer that question. As I mentioned, we had a lot of traveling nurses come through, and they did a fantastic job. But the ones that wanted to stay and put roots in, and they wanted to stay in the job that they're working in, couldn't do it because of these non-competes.
Okay, thank you. Other questions? Thank
Thank
you very
you.
much for your testimony. Is there anyone else who wishes to testify on Senate Bill 172? All right, seeing none, I will close the hearing and open the hearing on Senate Bill 178. Let's see. All right, does anybody want to talk on Senate Bill 178? Yes, Mr. Williams, we need a representative to open it. He's coming back. All right, thank you.
He's not here to hear it. He's not here to hear it, but this, Brian Chiricello came on his own. He's got no dog in the fight. This is a public service he did.
Yeah.
We appreciate it.
Correct. I mean, but his firsthand knowledge of being a county commissioner during this process is, I mean, we were.
He didn't have to come.
He didn't have to come. You are. He's no longer a Rockingham County commissioner.
I can introduce it.
Okay. We'll,
I'll bring you a pink card.
all right. Oh, wait a second. Senator Gray has put in a pink card.
He's shuffling in at the moment.
Okay.
All right.
Is he on his way in, or is he in another?
Yes, well, okay. This is entirely unprecedented, of course, but we'll have Senator Gray speak when he gets here. And Mr. Williams and team will explain it to us. You'll need 3 chairs, though.
Chairman McGuire and members of the House Executive Department's Administration Committee. For the record, my name is John Williams. I'm the Legislative Director for Health and Human Services, and I want to thank you, Madam Chair and members of the committee, for allowing the department to come here today to speak in support of the department requested legislation. It is a bill dealing with our lab water testing, and it identifies with fees. We have with us a wonderful scientist, Dr. Gao, who's at the very right of Mr. Baronelli. Mr. Baronelli is the director for the lab program, and he'll be here to present the department's testimony. We do have written testimony to provide afterwards, but again, given the brevity of time, he has very concise talking points for the committee. So, Mr. Baronelli.
Thank you, John. Good afternoon, Chairman McGuire and members of the committee. For the record, my name is Lou Baronelli. I'm the Water Lab Program Manager for the Department of Health and Human Services, Division of Public Health, Bureau of Laboratory Services. I want to thank you for giving me the opportunity to speak on Senate Bill 178. I'm here to provide testimony in support of SB 178, directing the Department of Health and Human Services to adopt administrative rules regarding laboratory services fees for testing of water supplies. The legislation is department requested and budget neutral. I also want to take a minute to thank Senator Gray for sponsoring this bill. Currently, 70 water lab fees are in RSA 131, Section 3-A, which was originally instituted as a statute of the Department of Environmental Services. In 2011, DHHS took over the Water Lab Authority from DES and inherited these fees placed in statute. I also want to share that except for water lab testing fees, all other public health laboratory fees are in Administrative Rule, HE-P 2205. This legislation would bring all public health lab fees, which are due to expire in 2026, into the rulemaking process and allow for a convenient, consistent, unified approach to setting public health laboratory fees. I want to thank you again for giving me the opportunity to testify, and I'm happy to address any questions you may have.
My first question is, have the fees in statute been changed since 2011?
The last time the fees in statute were changed was in 2007.
Thank you.
In statute.
In
That's
statute.
correct, and these are the ones that this bill would move into rules. Any other questions, Representative Leon?
Thank you, Madam Chair. Thank you for being here. My question is, it looks like this is moving from depositing the fees into the general fund and moving to having this go directly to the lab. My question is how the lab is currently funded, and just what changes that makes on the financial side.
That's a good question.
Great question. So going back all the way to 1995, the statute's been in place that 50% of the fees collected under the specific statutes that are enumerating the fees that Mr. Bernelli was explaining to you, half of it goes into the state general fund. The other half of the fees go into a dedicated non-lapsing account that's been in the Treasury. And again, that's been for 3 decades that procedure process has been in place.
So this bill changes it so it all goes into your dedicated fund?
Do you want me to answer that, or you?
Chairman McGuire, just drawing your attention to the bill itself, if you go into section 1 of the bill, and as I slowly get my glasses out, because we get a little bit older, our vision needs a little bit of assistance. I used to have it, obviously, eidetic memory here, but you'll see in here, starting on line 14, it says fees collected from public or private clients shall be deposited into the general fund with the exception that 50%, and then it goes on to saying that it'll be deposited into the Treasury account. That law has been in existence since 1995.
But the fees from grants or other state agencies go to the dedicated fund, 100%. That's what, that's on line 12.
Yeah, Madam Chair, if I might. So there are 2 major revenue sources that the lab receives, collects fees. One is fees that we collect from other state agencies to support the work that they do, and we do the water testing. 100% of those fees go into the general fund. Then there's another source of revenue that we receive.
That's not what it says. Am I reading it wrong? Right, that may be current practice, but
Yep.
this bill says on line 12 and 13,
Yep.
all fees collected from federal or state grants
Yep.
or from other state agencies shall be credited against the operating cost of the laboratory.
So I may have misspoken. That, to me, that means they go back into the general fund. I may have misspoken.
You may be operating under a misunderstanding.
Okay.
Or we're
My
operating under a misunderstanding. Somebody
apologies.
disagrees, yes,
And then the fees that we collect from everyone else,
right.
50% go into, let's see, the term, 50% go into unrestricted general funds, and 50% go into our laboratory dedicated equipment fund.
Correct.
Okay.
And this agrees with that. It's
Okay.
only the question of where do the state agency fees go? All right, thank you. That's Representative Leon.
Thank you, Madam Chair. And as I was looking at this, that language, it was in the part that's being replaced in what's becoming section 1. We're deleting the sentence that says fees collected under this section shall be forwarded to the state treasurer to be deposited in the general fund, which is where my question had come from on that.
So this will be very helpful. I actually have a handout of the existing laws so your committee can see it for the walkthrough, because Representative Leon is absolutely correct in terms of where we lifted the language, and I can explain it much better if you're actually looking at the language, because it doesn't show in the bill.
Thank you.
We, trying to grab it all. Thank you. We have, yes, all righty. Right. All right, so this is the same is it, well, we'll have to ask the senator about this. So is this,
Madam Chair, can we wait until the document gets to everybody?
We did.
Okay.
yes, all right. Super.
So Chairman McGuire,
It's
if I
the
could just
same
proceed through the walkthrough. So what is being repealed is the section currently in law in this chapter that deals with the enumerated fees that are in statute. And we wanted to preserve the existing language in the statute that's being repealed to roll it into what otherwise is a rulemaking statute for the department, which is in the following section in that chapter. If you look at the very back page, you're going to see what currently exists in RSA 131:4, and that's the chapter that everything is being put into because it's dealing with rulemaking. So it's the most efficient way to address getting everything into one area, one pot for the administrative rules process. Now, what you'll see, however, as you go through the legislation line by line here, the first section where it talks about the rules adopted, you'll see that's reflected in the current law. The only thing that is taken out of that is the last sentence that you'll see on the back page here, which are fees collected under this section shall be forwarded to the state treasurer to be deposited into the general fund. And the reason why this section that deals with the rulemaking provision only address those rules that Mr. Barnelli had explained to you are in administrative rules. So to align this with the current provisions that allow us to keep 50% of those dedicated accounts to help support the programs for equipment costs and other fees, it was important to roll the existing language from the statute that we're repealing into the same section. Does that make sense so far?
Yes, I still don't understand the language. Where it first says that all such fees shall be credited against the operating costs of the laboratory. I mean, that says to me that the entire fee is going into your fund.
And that is not the interpretation that we've had. Only 50% of those fees as they relate to the fees in statute go towards that fund. That's the way we've been administrating it. And it's at least the language that we have been using. In that language, again, all of this that we're referring to has been an existing law for some time. So I appreciate your
I think it's
question.
broken, but it's not a new problem. Okay, does anyone else have any questions? Representative Broda?
I just want to clarify that the section 2, which is in this handout that you just gave us, is supposed to be what section 3 of this bill is. Of
Yes.
the bill, yeah, that's right.
Yep. Good. Are there any other questions? Representative Pearson?
Thank you, Madam Chair. So since we're beating up paragraph 3 here, the fees collected, line 14, fees collected from public or private clients shall be deposited in the general fund, blah, 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 right? Is there any other person or entity that utilizes these services that are not public or private clients?
Have to turn it on right.
I'm sorry. Thank you, Representative Pearson. Good question. So there are no other clients other than the general public or that covers all of our clients, other than state agencies, general public, or other. Yeah.
Okay.
Public or private clients. That's it.
And Representative McGuire, if I could just ask, Representative Pearson, if he had an entity in mind, we could certainly address a very specific leading question if you'd like to pose that to the department. But the folks that we serve are, private citizens. If you have a well, we're a very rural state, and you might need to have your well water tested. We certainly supply those services to them. You'll see a whole litany of the 70 types of things that we would test for, like ammonia and other various things that are in the water. The other major actor that participates with us is the Department of Environmental Services. You'll even see a section of the proposed language here that actually makes a correction to the cross-reference based upon this new law for the environmental services folks.
Yes, Representative Schmidt.
But our question is not about the services provided, the question is where do the fees go? I think that's where we're trying to get straight here. Not whether the services are provided and by whom, but where the fees for those services go.
All right. Since it's the same as the existing law, I think we will,
I think we are comfortable with the idea that nothing is changing? Steve?
Thank you. We'll,
okay with it? Yeah. Okay, if everybody's clear with that, then we can proceed.
all right. Are there any other questions for the department? All right, seeing none, thank you, gentlemen. Senator Gray, I'm sorry.
Thank you.
We jumped ahead. I apologize.
Not your fault. It was my fault. And
Well, I'm sure we can blame the Commerce Committee, yes.
I was at their table testifying on a bill when I should have been here.
Well, that's all
And
right.
Representative Hunt didn't seem to want to stop the questioning, so I continued on. My name is James Gray. I represent Senate District 6, which starts up in Alton, and Gilmanton comes down Route 11 to Rochester and Stratford. This bill is a lot different than when it first came to me. The first request for me, because of the dedicated fund, was, well, hey, we need all of that money to come to the department and none of it to go to the general fund. Having a crystal ball and knowing that the chair of finance was saying, well, gee, I need all the general funds that I can get, said, no, we're not going to do that. All right. And we talked about a whole bunch of other scenarios. We looked at other departments that could help to fund the piece of equipment that they were originally, looking at buying. We looked at UNH and how their water testing facility could assist us in whatever. And we came down to what you've got in front of you. Okay? Is that many, many, many departments have the ability to set their fees and rules. Makes it much easier for them. It makes it much more responsive, helps to aid our budget. And that's what you've got in front of you right now. If there is some wording either in the existing language or whatever that would make it more clear that that is a 50-50 split, or that the money that is going to is only that portion, that is assigned to the department, go for it. Okay? When it comes over, as long as you're doing that, I will happily concur with the bill, and we'll send it back to you, for your passage. Okay? So if there's questions, I'd be happy to answer them, but this really should be, just a question of whether I'm going to set the rules in statute or the fees in statute, or whether I'm going to allow the department to set those fees by rulemaking.
Okay, thank you. I think that makes the intention very clear. Any questions?
No, you said it all, I think.
All right, excellent job. Thank you very
My
much.
wife
for your
says I don't
testimony.
talk enough, so if you.
Okay,
Get her on the witness stand.
okay. All right, does anyone else wish to speak on Senate Bill 178? All right, seeing none, I'll close the hearing. Representative Sychek, you have a motion?
No, I meant all this talk on water. But no, I do, look, the intention is very clear, but the language isn't. I'm amazed you've glossed over that fact. It should be, what's our policy?
So-
If our policy.
Representative Pearson, do you have a comment on that?
as I'm
I think
looking-
it's confusing.
Almost as if the first sentence in the third section should be in the middle. instead of being the primary sentence of the paragraph, where you've established the 50%, the separation, and then say all the fees collected shall do their thing. But you lead with that, and I agree with Representative Sytek, you lead with that, and it says what it says. It says all of them, and I appreciate the fact that they're not operating under that, but the word
It seems
vomit
to
is
me
horrible
as-
here.
As though the first sentence is irrelevant. Because you could just say fees collected go with unrestricted revenue, except that half of it goes to this dedicated fund.
The only part, Madam Chair, would in part 3 though that does separate a little bit off the fee part would be the state grants, I suppose, but that could be added into that other sentence. But I don't know if that state grants is self-imposed. That's our own business, but the federal grants.
Well, are public clients state grants and federal grants? Representative?
So the
would
thing
think
is,
so.
if this language is confusing, and I think we all agree that
It's
it is,
confusing.
then it's going to be seen by everybody in the House and the Senate and the general public and the profession and so forth. It's going to confuse everybody who's not going to have the benefit of this colloquy that we got going here to straighten it all out. So if we don't like the way it's formulated, even if we agree with what Senator Gray wants to do, which I think is appropriate, I think it's better to have it in rules than in statute, then we ought to have the bill rewritten so that it has the best language we can come up with.
All right,
Right.
Representative Leon, your subcommittee hasn't gotten a bill yet. If you'll take on rewriting that paragraph so that it makes sense to us and says what everybody agrees it should be saying,
Right.
I would appreciate
And,
it.
and John Williams has been sitting back there nodding his head in agreement that if and you are an attorney, are you not, John? Okay, so if you agree that the language is not great, then we should get it as good as we can get it and not leave
Since
it.
we've got the bill, we ought to fix that language.
Exactly. Now's the time. We have it.
Exactly,
right,
that's
we
the
have
point I'm
time.
making.
All right, thank you. That's a good point, and we have a few minutes before our next hearing, so we're in recess until 2:30. passing on Senate Bill 180, and I call Senator Rochford.
Good afternoon, Madam Chair, members of the committee. For the record, my name is Senator David Rochford. I represent Senate District 1, which covers the top third of Grafton County and all of Coos County. And I'm here to talk about Coos County in this bill before you, Senate Bill 180. It's a, as many of us know who have traveled along the state, we have various parts of the state that the characteristics vary widely. And there's no other variation greater, in my opinion, than the characteristics of Coos County. We're the most rural state. In fact, my district, which is all of Coos County, I cover about a third of the state in geography. So it's very different. The challenges that we face in Coos County are very unique to that part of the state in relation to the geography and the large area that it covers. Some of those are infrastructure, bridges, roads. We have the most unpaved roads in the state. We have one of the largest percentages of Medicaid in the state. But we have what we've experienced, particularly over the last 20 to 25 years with the departure of the paper industry. We have a state that some, where I come from, call a chronic state of recession. We're often the first ones to go into a recession, last one to come out of a recession. But 25 years ago, with the loss of the paper industry, that was our major employer. And when I say major employer, when you graduated from high school, you could get a job in the mills and support a family and be there for the rest of your life. That's gone. And in addition to that, we've lost other employers. Balsam's Resort up in Dixville, gone. There's been a number of other smaller employers that are gone. And it's created a situation that has left our most northern county in a state of distress. And it's a state that we live in. I'm born there. I was born there. I'm from there. But it's been particularly tough in the last 20 years or so. So the point of this is when we legislate down here out of Concord, the one size fits all that we're often are faced with really doesn't fit a lot of times up north. So we wanted to bring forth this bill that would designate the legislature would designate Coos County as a distressed place-based economy. And what does that mean? That just means that the state says this is a part of our state that is distressed. What it will do, we've been in touch with many economic development professionals, not only in the region but outside the region. It will elevate our status when we're competing with other parts of the country for grants, economic development opportunities, things like that. There are other states around the country that have done similar types of things, and where our geography is, our demographics, and our population, it would make us a little more competitive when we're competing for those types of things. Things like rural Appalachia, West Virginia, Tennessee. I think Georgia has done some various things, and that's the first part of this bill. It just designates that as a distressed place-based economy. It will assist our economic development folks that are working to attract business to the North Country, boost infrastructure such as broadband, et cetera. It'll give us a leg up when we're competing with those things. The other thing that it does is it compels certain state agencies to consult with our county commissioners when they are doing county projects or authorizing projects that have a countywide impact. What we have found recently is our county commissioners have no more standing than a member of the public, yet they often have a lot more knowledge and institutional background of the community, of the county, than a member of the public. So what this would do is it would compel, when agency commissioners are implementing large plans that affect the county, they would have to consult with the county. When I say that large plans, we're not talking about
driveway permits or wetlands permits or things like that. One of the things that really came to note recently is the state holds an easement on 146,000 acres of land up north. And this was negotiated 20 plus years ago, and the easement lies in DNCR. And there's discussion, ongoing discussion right now to renegotiate the easement. And we feel the county should have a seat at that table, along with other tables that affect the county. And this would compel the department to take into account what the county has to say, more than just a member of the public. So that's what the bill does. I'm happy to answer any questions on that. And I know there are people that came down all the way from Colebrook today to help as well. So
Representative Schmidt has a question.
Thank you, Madam Chair. So I don't want to get too much into it, but Maine has an even larger county that is probably extremely similar in terms of being distressed and so forth. So have you looked at what Aroostook County does and how it's set up and would that be of any help to you in terms of, and I don't know, maybe they're no better off than you guys are in terms of how the state treats them. But I think this is a great idea. So I'm just wondering, because as I say, when
Yeah.
you look at Maine, you see, boy, is that really big.
And Aroostook County shares a lot of the same challenges that Coos County does. They, like us, have lost our industry in the paper mills. A lot of that industry has been shipped out overseas, and we don't have we're struggling in the same ways. I know Aroostook County also has challenges with infrastructure, transportation. 95 goes up, but it largely misses most of the county. This was brought forward to me by a economic development specialist who has traveled around the country. Whether she consulted with Maine or not, I don't know, but she felt that this would increase our competitiveness for some of these things. So we don't have to come back to the state and say, hey, help us out. And the goal is to be able to capture some of these other things that are out there that are available to distress place economies.
Hello. Representative Schmidt. Representative Dargy has a question.
Thank you, Madam Chair, and thank you for taking my question. The phrase distressed place-based economy, is that used someplace else in the country? I mean, where did you come up with that exact phrasing?
This came from the economic development specialist. I think that the whole concept of place-based economy is that's the terminology that is being used right now in economic development. Previously 10 or 15 years ago, they used to call them opportunity zones. This is specific to areas that are distressed. I'm under the impression that this came from other programs that were going on around the country.
Could I just weigh in for a second, because as
No, Representative Schmidt.
we have to understand the language. So it's not that it's a place-based, it's a distressed place. That's the term. The hyphen is misleading. It's a
Thank you,
distressed
Representative
place,
Schmidt.
and
But
it's
this
based.
is what the senator has brought to us, however incorrect it may be.
It's not incorrect. We have.
Yes, thank you, Representative Dargy.
But using that phrase, does that enable you to go for grants? I mean, is it specifically in
It's
language
exactly what
in
it
other
does.
states?
Yes.
So it's something you can say, we are a distressed place-based economy, so we qualify for X, Y, and Z.
That's exactly what it does. And as you know, when you go for grants, there's the application is scored, and there's a score that's given, and if you check off a number of boxes, that your application gets higher on the list. With this, and again, this is anybody could call anything they wanted. But the fact that the state, the point is the state is recognizing formally that this is a distressed place-based economy will increase our competitiveness as we go for those grants.
Thank you. Representative Howard and then Leon.
A question of the chair. Do we have anybody from the Fish and Game Department?
I don't see any. I don't have a card from anyone in Fish and Game.
Okay. All right, follow up. So thank you, Madam Chair. Thank you for taking my question, Senator. So I'm just curious as to why the Fish and Game Commission opposed the bill in the Senate.
Yeah, that was, I don't have I may have the hearing report in front of me. And actually, I think someone from the county can probably speak to that as far as why it is. I don't remember, I think there was some concern initially about, well, now I do. Yes, now I remember. I believe Fish and Game and the Department of Transportation shared some concerns in the original bill that they were concerned that every decision they made in the county would have to be run by the county commissioners. So whether it be a driveway permit, a wetlands permit, and I think that was rectified and clarified in the amendment that came out of the Senate. I believe that the Fish and Game's opposition was along those similar lines. They didn't want to be micromanaged, and that was not that was not the goal. It was more larger decisions that affect the greater part of the county.
Yes, you'll notice that the fiscal note is still from the as introduced version.
Okay, thank you.
We'll have to see if there's a later one. Representative Leon.
Thank you, Madam Chair, and thank you, Senator. It's good to join you again today.
It's been a long day.
Yes, it has. My question is about what types of grants and opportunities you would be competing for, or the county would be competing for with this change. I'm not sure what sort of examples you may have that have been brought forward.
Yeah, I don't. I mean, that's more the economic development specialists would be able to speak to those specifically. They are federal grants, but the type or the name or the department, she would be the one to provide that information. And I don't believe she's here today.
Thank you. And as a follow-up, my question is just around sort of how long they are, and if once somebody gets involved in it, it's important to keep those federal grants going, even if the conditions change, because I know we had another bill to address what some landowners saw as economic opportunity by getting some carbon credits for that, but we needed to then balance those needs. And I'm just curious if you're worried that some of these opportunities may actually end up in the long run becoming an issue of balancing those needs with local control.
I hear that because the carbon issue is very near and dear to my heart. It's affected negatively my constituents in many ways. I think the fact that we're looping in the county commission on this, where they have, on various decisions, and maybe they're two separate things, but I feel confident that they can discern and clarify some of that to ensure that doesn't happen.
Thank you. Other questions? Yes, Representative Salachi. And then Debris.
Thank you, Madam Chair. Thanks for taking my question, Senator. I guess I have a question for you about, when I was young, I was raised in upstate New York, and we had what was known as economic development zones, and there were places where it was sort of concerning to trod. And I'm not sure. I mean, there's the adage of like most people die in hospitals, so stay away from hospitals. So that might be going on too. But do you have any concerns, I guess, about such a designation leading to, the sense of, your county becoming some sort of exclusion zone?
Representative, I've lived there my whole life, and it's an exclusion zone now. And it has been for a long time. It's gotten worse since our mills left. So no, I think I look at this more as an opportunity rather than a threat. And it's a beautiful part of the state. And it's, again, I want to hit on something because some of the people that have initially brought concerns was, well, this is going to bring condos and develop. This isn't what this is about. This is about bringing, giving tools to the folks that are involved in economic development in the state to have some extra resources to get out of that hole that we've been in for so long.
Yeah. Representative Rees.
Thank you, Madam Chair. Thank you, Senator. Mine is a language question on the second page of the bill, starting on line 7, prior sentence talking about agency commissioners. It says, if a decision is found, and that's a state decision, one would assume, if a decision is found to negatively affect the region and is unavoidable, commissioners of state departments must provide Coos County government with a clear justification for the decision. And here's where my question comes in, and develop mitigation measures for undermining revitalization investments to improve the economic performance. My question is, does the second half of that sentence, and develop mitigation measures for undermining revitalization investments to improve the economic performance, follow from the first part of the sentence where it says, if a decision is found to be negatively affect the region? Negative affect doesn't necessarily mean that revitalization is undermined. So it's really is that appropriate language?
Let me give you the context of that.
Thank
And
you.
if you want to clarify that language, you're in committee, you're welcome to do that. So we understand that there are decisions this goes, again, to reiterate, this goes back to, we have for many, many years been subject to decisions made in Concord by people that have no idea about the area and the region of the state that they're affecting. They don't understand the whether it be natural resources, whether it be pollution, whether it be access to recreation, a variety of those things. So the first part of that is bringing the county to the table on a level as a participant, not as a member of the public. So that's goal number one. We recognize there are instances where the state's just going to have to do what the state has to do. So what it's asking for, the purpose of that sentence was, if the state's going to do what it's going to have to do, you at least have to provide, the state will have to provide the county with a reason why, and work with the county to come up with some consensus or some mitigation to bridge the gap between what Concord's telling we need and what the locals are saying is needed. So it will enforce some collaboration around that. So I know you got to follow up, but I'm going to keep talking for a minute if I could. So the case in point with this. So I talked about, and this is fresh on my mind, but we could probably go on. I know the folks behind me could talk about other cases. The case in point with this, we've got 146,000 acres that is owned, well, it's owned by a company, but the state owns an easement on it. The state and the federal government, when they bought this land 20 years ago, they said, well, we'll back the loan, if you will, we'll participate in the acquisition of that, but you got to give the state an easement. And so that went through. The state holds an easement on this land that allows for traditional uses, logging, hiking, snowmobiling, fishing, all of the traditional character of that piece of land. So fast forward to now, the company that owns it wants to renegotiate the easement, particularly about the cutting and the logging part of that. And there's a lot of concern in that, even though we don't have paper mills, we do still have a logging industry up there. And with 146,000 acres that's supposed to be logged, that's a pretty significant provider of economic basis. So and I'm taking the long way, I know, I'm sorry, but the point was they wanted to renegotiate the easement and lower the amount of cutting that has to go on, that's permitted. So part of the easement says lower the amount of cutting. The owner wants to lower the amount of cutting because it's in a carbon program, and we could go. I don't want to get off track here, but so as the state is considering this, and the department is listening to the argument of why we should lower the amount that is cut every year, the county is on the back bench. They're just a member of the public, and the county asserts that any lowering in the amount of cutting is going to hurt a variety of things. The first one being our local economy. So the state might just say, we're just going to do this. We're going to lower the cutting, but we want to have a reason why. Is it because there's a legal reason? Is it an environmental reason? Is it a resources reason? You know, we understand, I don't think we're unreasonable. We understand that the state has to do state things, but we want to have that dialogue, and we haven't had it. And it's been, and we think it's a necessary component of this bill.
Follow-up?
Thank you. And that was a great explanation. I followed all of it. My question is, and it's very helpful in understanding the language of as this bill is written, because I think that what is happening here in the language of the bill is that it is assuming a undermining of revitalization investments. And I am not sure that that follows from a decision that the state takes a different decision, not related to the easement on those 146,000 acres, that the state may take some decisions that may not benefit, but a decision that may not benefit doesn't necessarily undermine.
Sure.
So I'm just thinking that language is a bit too, it doesn't necessarily follow in all cases. It may with 146,000 acres, but I'm not sure that it does in every case.
Sure. Well, you know the background. You've got the bill. And you know where we're trying to get. If there's better words, this committee is I'm sure will be, tasked with clearing that up.
Thank you.
Other questions, Representative Slotching?
Thank you, Madam Chair. Just a quick one. One thing I didn't see in here is an exit plan. So say 50 years down the road, a new golden age arrives in your county and everything's great. How do we get out of this
I
zone?
hope that happens. And, I'm optimistic. I've never lived there my whole life and, don't plan to die there. But that's a good question. Maybe we'll come back and say, let's call it something else. But, that's certainly what's what we could hope for.
Follow-up?
Thank you. Primarily my concern is that because this designation confers an advantage to the county in terms of bidding and all of these various items, it becomes I imagine it would become very difficult later on to give that up. If things go exactly to plan, if I were a resident of your county, I'd be very hesitant to try to give up this designation because it helps me win contracts. So do you think it might be appropriate to include within this legislation of designation an end date or a method out of it?
A sunset.
Yes. Where it does not need to be negotiated later, because I imagine that negotiation would be fraught.
Yeah, no, I think that's let's hope that happens, and let's hope that we are a golden opportunity place-based economy in 10 years. I think that's a good point, and I'm optimistic we can.
Representative Slotching, I think that's one reason why the opportunity zones is no longer current, because it was applied, and if somebody has come out of being an opportunity zone, they wouldn't want to get rid of it, but it doesn't help you anymore. That's why I have one question. How would this bill be implemented? I don't see how it would work in practice.
So the way of implementation is really, when this is, the legislature has declared this being a distressed place-based economy, and then the applicant can, in their application, can say, our legislature has declared this a place-based economy. I imagine BEA would probably participate in this. I'm sure I'm speaking for them now. I haven't talked to Commissioner Caswell about it, but I can just imagine that this would increase opportunities for them if they were able to say, we have a county in our state that's a distressed place-based economy, and they could use that in their, as they do their business.
But say, renegotiating the contract with the owner of the Connecticut Lakes Forest. I mean, who would be charged with making sure Coos County gets a seat at the table? It's not at all clear to me that there's any definite procedure here. Or should DES specifically invite Coos County when they revise their septic rules or something?
Well, I think that it goes, where is it here? I think that is addressed here in, well, yeah, agency commissioners shall ensure that any management plans or decisions in Coas County promptly and thoroughly consider. So it would be up to the agency to loop in the county commissioners.
Okay. Thank you. Representative Ferrari, you have a question?
So I think the idea is admirable. But I have the same concerns that that the chair has, in that you say that the agencies will loop people in, and then you think of agencies being, first of all, let me back up, I'm sorry. How would it be that how agencies are looped in would not lead to different regulations or different legislation in Coas County than other counties?
The way I understand this is, how would the agencies know to delineate Coas County versus other counties?
Follow up.
Yeah, follow up. No, what I mean is, let's say that there's a discussion between the county and the agency about something. However, the agency wants to have one set of rules for the whole state, but Coas County commissioners don't want that. And then that negotiation could lead to two different sets of standards. Is that possible?
Well, I think that's where we allow. I mean, we understand that there are instances, in the instance that you brought up, where the state is not going to give a carve out to Coas County. They're not going to say, yeah, the septic systems in Merrimack County can be built to the. And I'm using septic systems. This really doesn't get to that, but this initiative in Merrimack County doesn't apply to Coas County, or vice versa, and or the rules that apply to town forests in Sullivan County are different than the rules that apply to town forests in Coas County. And we understand that it's just not work. Sometimes the state is just going to have to say, deal with it. I mean, we're not going to give you any special advantage or carve out or anything like that. And but the bill just requires them to tell them why. And again, looking at this, we're looking at primarily projects that affect only Coas County, whether it be the 146,000 acres that I talked to you about, changing a OHRV rules that largely affect Coas County. That was another instance that we had over the last year. They kept the OHRV trails in every part of the state open until a certain date, but in one section in Coas County, they closed 9 miles of it for 2 weeks ahead of time. And again, that was a big decision. It was, so we understand that there are instances where it's just not workable to take into account, but the bill would require that the agency explain to us why it's not workable.
Follow up.
But shouldn't that be for all county agencies?
I was approached by the Coas County to come here and work on them, so I think that's I think transparency and communication is great and wonderful, and I think we've all experienced instances where there's our agencies work hard and they do a good job, but sometimes there's been we've seen it. This is what we're going to do. You're going to take it, and this is an effort to at least address that, to give our counties more say at the process, and if they can't do it, it compels them to communicate why.
Thank you. Last question.
Follow up.
So is it not enough, or let me rephrase that, could it be that just calling the Coas County a distressed place-based economy through legislation and be enough of an assistance to Coas County that they are able to apply for grants. I guess I'm concerned about the mandating state agencies to the state agency Coas County Commissioner portion.
Yeah, I'm gonna actually. There's a commissioner, Coas County Commissioner here today, who plans on testifying, and I would hope that he can address that for you.
Thank you. Representative Leon?
Thank you, Madam Chair, and thank you, Senator. When I put on my Rockingham County hat, this sounds like a fantastic tool if we were able to use this. But putting on my state hat, I see a lot of really expensive potential gridlock if this happens for Coas and then gets spread to the other counties. My question would be for you, if we were to go for the smaller bite and just do the distressed place-based economy, if that would be enough, if we were to pass that alone, or if this is just a package deal and it only makes sense if we include all of these different sections.
You know, I think that the distressed place-based economy would be that would be monumental for our county. I think that would really help us out with that. You know, it sounds like there is some questions and concerns, and you know, we've got, like I said, the county commissioners coming up here to speak about this after me. But you know, if that's what it took to get the first part, I think the first part is more important than the second part.
Thank you. Other questions? Representative Sytek.
A quick irrelevant question. What's going on with the balsams today?
Again, I got somebody behind me that'll give you a really up-to-date talk. But I can tell you that I spoke with the developer just last week. He continues to be optimistic on that. You know, I think they're lining up some of the, you know, according to what he says, they're lining up, you know, some of the latter pieces of financing, and you know, I think the community is excited to see them, you know, break ground, and you know, whether it be the community of Dixville or even Colebrook, because Colebrook will benefit from that as well. So we've got somebody here that I'm sure could speak far more intelligently on that, as he worked there for 30 years. So we're all hoping for wonderful things up there.
Take care of the golf course.
I'm told the golf course has been maintained at least minimally, so it hasn't been grown up. That's what I'm told. Every time I go there, there's snow on it.
All right. Anyone else? Thank you, Senator.
Great. Thank you very much.
Representative Corson?
Good afternoon. My name is Lori Corzin. I am the state rep for Coas 7, which is Berlin, Whitefield, Jefferson, Kilkenny, and Twin Mountain. I am very new at this, so forgive my nerves. But I do feel like I needed to be here today to talk, to do whatever we can to help Coas County get back and up and going. I came at this more with looking at the economic trends. I'm not sure people are aware of how much lower Coas is. The median household income in Coas is $58,000, whereas in Rockingham it's 97. The New Hampshire state average is 97. Our poverty rate in Coas County is 12.9%. The average for the entire state is 7.2, with Rockingham coming in at 5.1 and Hillsborough coming in at 6.8. What else? I have unemployment rates, which Coas is 2.9, compared to the state is 2. Wage trends are the lowest in the state. The job loss and growth data point that I looked into is eye-opening, and that's kind of one of the reasons I actually made the chart, just so you could see it. The employment in Coas County from 2001 to 2002. Hold on, let me just get there. Nope, from 2009 to 2018, Coos County lost 1,011 jobs, while Rockingham gained 18,000 and Hillsborough gained 16,000. To me, that was very significant in that we lost 1,000, whereas the other counties in the state are gaining. Population growth is declining. Housing cost burden is declining. Not sure if you're aware of what that is. I just found out myself. But it's where 75% of the renters in Coos pay more than 30% of their monthly income. And that's extremely high. I can give you other indicators, but Coos County trends as persistently distressed with slow and insufficient improvements. Getting this designation for Coos County could help everyone. I'm here today for the families up in Coos who've lost their jobs at mills. People are struggling. We want to keep our kids. The only way to do that up in Coos is to be able to have jobs. And to get the jobs, we have to invite companies to come in. We have to get some of these grants. So I'm here today just asking you to consider this option. Thank you.
All right, thank you. Are there any questions? No, apparently. Thank you for the
Thank you for
data.
the no questions.
All right, Commissioners Gorman and Tebow? DeBeers, excuse me.
Thank you, Madam Chairman, for allowing both of us to testify together. We're both commissioners in Coos County. I'm from District 1, and I'll let Commissioner Gorman introduce himself.
I'm from District 3, which is kind of typical of Coos County. I start in northern Pittsburgh, and my most southern town is Twin Mountain and Carroll. So I cover a lot of ground. It takes me an hour and a half at least to get from one end of my district to another with District 3. And I'm sorry I didn't bring more copies of this letter because some of that has some good information on questions you folks have asked earlier with David here. And David did a fantastic job explaining part of the situations that's going on. But so I'm going to just read the first couple paragraphs of the letter that the commissioners have put together. And we really want to declare our support for SB 180. As you can see, the county's elected representatives, both the state House and Board of Commissioners, are unanimous in support for the bill. The legislation will have practical effect for making the county more competitive for federal grant opportunities. Coos checks the box for so many of the factors that define distressed place. And we describe, and I got here for distressed place that you asked about, a geographic area characterized by high levels of poverty, unemployment, low median income, a declining population, and a lack of diverse employment opportunities. So we are the only county in the state that had negative population in the last census. We are 21 or 22% of the landmass of the state of New Hampshire. And one of the unique features about Coos County is and I use the village of Pittsburgh as an example, there's 800 residents in Pittsburgh. Of those 800 residents, they own about 25% of the property. The other 75% is owned by people from out of the town and from the state and around New England. And so with that 800 people, on any given weekend, summer, winter, fall, hunting season, there's, with all the lodging that's there and all the activities on the Connecticut lakes and stuff, there's 5,000 people there. It's like if you go over to Arrow and Lake and Bagog area, same thing. You got a town under 1,000 population, all right? And we're providing services and so on and so forth for and all these folks that come to spend the weekends with us. It's expensive for us. And I'm going to give you an example. I also am part of what they call Northern Borders Dispatch. And we've been applying for grants. We were turned down twice for a $1 million grant to basically just upgrade our dispatch center with mapping, all the computer programming that you need, and much better communications between fire, state police, New Hampshire, the ambulance people, all those groups there, so they're all under one set of channels, better repeaters, so on and so forth. We were turned down twice, and what happened was with that grant was the 1,500 square miles that we served had 5,200 people in it. So when they score that, all right, that 5,000 didn't give us many points. Okay. So this is, one of the examples that can go each way. All right. So I'm saying to you folks today that if we can get declared this, as we've asked here, low median income with the distressed places, that maybe this does help us with grants. I am also a Colebrook selectman, and we have some significant, we have probably, I would say, $7 to $8 million worth of water, sewer projects, safety things that we're doing in the next 5 years. And we're going to need every dollar we can get from grants, et cetera. I know Lancaster's in the same place, Gorham's in the same place. These are all towns that I represent. I don't represent Lancaster, but as a county commissioner, we represent the whole county. And I think Robert will talk a bit about Berlin and its situation. And it's been tough for us. David referred to the Balsam. We had the Balsams questions. I worked there 32 years. And now the place has been closed for over 13 years. And it was devastating for me to lose my job. My brother and sister both lost jobs as well, but my sister worked in a furniture factory with her husband, went down from 600 employees to 100. My brother worked at the paper mill, closed. And we all, middle-aged to older, having to do 2 jobs just to keep the type of life that we'd had before with good jobs. And very optimistic about the Balsams right now. Got calls this week about what we call Golf Links roads that the state had committed. We got some legislation in for the state to fix that road. So there's a lot going on there, and we're very optimistic. But also that's going to put pressure on like a community like Colebrook. We're going to need to be able to have the sewer and water. The Balsams came to us. They want for temporary employee housing. They asked if we would take their sewage. This is for a fee, of course. But, once we start adding those numbers and we only have a certain amount of capacity, that's the thing that a lot of the communities are facing. And so we're just looking try to get some type of help. And we are begging. There's no doubt about this. We're here trying to do the best for our area. I'm a lifelong resident of the North Country. And we're just trying to get any points that we can when we're trying to get these monies, so on and so forth. And, I can answer questions to that. As far as, I know DOT and Fish and Game, some of their concerns, the Fish and Game concerns are significant, okay? And, I can get into it. Just seems like we're, I want to be careful how I put this, but sometimes it just seems like we're kind of forgotten up there. Okay. I believe sometimes some people think the state ends at Franconia Notch. Thank God we got Littleton. All right. The interstate's going there and stuff like that. But you get much further. There's a lot of our state residents have never been north to places like Colebrook, Pittsburgh, so on and so forth. But we also have the Mount Washington and Gorham and all those areas that do very well with the tourist business. And they're a very big part of our state. They're a very important part recognition-wise. When people think of the state of New Hampshire, they think about, the lakes, the mountains, Mount Washington, et cetera. And, as commissioners, we also have these 24 unincorporated towns trying to get this, we're selectmen for 24 of these communities. Some of them have no population at all, so it's fairly easy. But you hear what I'm saying? It's a different game than I'm talking about when it comes to managing a large area that we have. And we're just trying to get advantages to help us do a better job with this. And I'll let Robert speak about Berlin and so on and so forth. I really appreciate your time today and look forward to answering any questions you may have.
Okay, yeah, thank you. For the record,
excuse me.
I'm Commissioner Robert Tibels, represent. Oh, I'm sorry.
Representative Sitek?
How many miles did you drive to come here today?
So it took me just under 3 hours. Okay. I tried to catch 2 committees, but I failed downstairs. I thank God I had the other gal to cover for us. But we know that fact. Okay. 2 hours is just a standard thing, Plymouth, that's how, my closest market basket, unless you go to Conway, and Conway's 2 hours for us. So, it's a gallon of milk in Colebrook is $4.75, the cheapest you can find. So there's a lot of some of those things because of our remoteness, our people pay a lot of money, so.
Thank you. Representative, you have a follow-up?
No, I'm going to, I
Okay.
want his name.
Oh, okay. For the committee, I'm Commissioner Robert. The last name it's French Theberge, Theb as in boy, Erge.
Oh, okay.
I represent COAS District 1, which is Berlin and Milan. So I've got the smallest district, but the largest population. If I'm addressing population, I did the census, a few years ago, and I was a shocker for me to look at the facts and figures relative to Coos County. I also did Northern Grafton and Northern Carroll, night and day. With amongst those counties, the population at the end of Coos County declined. The population of Berlin declined from a little over 10,000 to barely now 9,000. We're having problems with employment, housing, typical things. We're working very diligently on I'm also on the city council on our budget. We're trying to reduce that by 3 million because our population, can't afford it. The majority of our population are elderly and retired and on fixed incomes. I can go on and on and on about our situation, but having the number of unincorporated places, puts us in a different realm of things and different issues because of the lack of population. What really troubles we commissioners, and I know the chairman, Tom Brady, couldn't make it today, but Commissioner Gorman and myself, is that we generate a lot of room and meals, income tax, but we get very, very little. People come to the North Country for recreation and whatnot. I know that for the ATV festival in Berlin, we bring in over 30,000 people. For the Riverfest, where we light up the boom piers along the river, we bring in about 10 to 12,000 people. So we generate a lot of money, but what we get for room and meals is a pittance compared to, it goes to the state coffers, and we feel that we don't have our fair share. So that's part of the problem, So we're looking to be treated, fairly and equally, as a county, but we do have our challenges. And despite having our challenges, we work with Commissioner Gorman and I. We're both on the COAS Economic Development Corporation. We're looking to not only address issues with small mom and pop businesses, but to work with Bino Lamontagne, as you know, for the state to attract businesses from Canada, and which is, when we're the only county that borders, Canada, and my first language is French, and so Bino and I work really, really well with the Trade Commission. So those are some of the things, and most of the points that I wanted to address were brought up by Commissioner Gorman. So I don't want to belay more of your time, but I'm just here to let you know that we would like, to be viewed as, differently, because we have different problems facing us, and hopefully that will change in the future. We're looking at ways of improving our economy. We're addressing that at the county level, and I know that some corporations are working with us, and so hopefully that changes, but it's going to take a while. We keep losing our young, our younger population, younger students that are immigrating out. So that is a challenge, and housing is a big, big challenge, I think, for all of us, throughout the state. Thank you.
Thank you. Any questions? Representative Saïtek?
You still speak French?
Oui, tous les jours. Merci. Vous parlez français?
Je parle un petit peu aussi.
Thank you, gentlemen. Any other questions? All right, seeing none, thank you for your testimony.
Ok, mon plaisir. À la prochaine.
Thank you very much, folks. Appreciate your time.
Kate Horgan?
Thank you, Madam Chair. Members of the committee, my name is Kate Horgan. I'm here on behalf of the New Hampshire Association of Counties. The association does support Senate Bill 180. Anything that we can do to give our counties a competitive advantage when they're applying for grants. As the commissioners did a great job laying out how COAS is different, they are even more different from the majority of the other counties within the state. They have the most unincorporated places. They have small populations. They struggle constantly with housing, unemployment, things like that. The commissioners have said to me, you know, even when the state's doing great and isn't in a recession, COAS is still in a recession. So they just need that competitive advantage. So the other 9 counties just wanted to support anything we can do to help COAS out. And I'm happy to take any questions. Thank you.
Actually, I maybe you can answer the question.
I will try.
I understand the declaration, that's straightforward,
Mhm.
but how would the agency regulatory principle actually work?
I think what you could do, and this is just a suggestion, I have not spoken to Coas County about this, but you could add a requirement that any changes that would be drastic to Coas County should be required to go in front of the Board of Commissioners to be part of their agenda. That way, then the discussion is happening. They meet monthly, they meet every month, and it would be a way to ensure that those discussions are happening. Because I know Coas County has struggled with communication with some state agencies.
Well, they would.
But
I'm still not sure how it would work because it would rely on the agencies to realize that it would affect COAS. And if the problem is that they don't realize it.
And I think if you wanted to restrict it to stuff that just impacted COAS, Madam Chair, that might make it a little clearer, because if it's a statewide decision, it's a statewide decision, right? So if it's something like the trails are only closing in Coas County, they should probably have a conversation with Coas County.
Well, it's mostly because the bulk of the trails are in Coas.
Correct. Correct. So that could be a suggestion too, to, not make it so that it's so overburdensome.
Thank you. Any other questions? All right,
Thank
seeing
you.
none. All right, does anyone else wish to testify on Senate Bill 180? All right, I will close the public hearing. And what do we got there? I don't know. I'm not sure it needs to, but do you think it does?
I think it's a subject that
Okay, well, let me think about it, but I'd like to go into executive session on Senate Bill 172, and Representative DeVries has a motion.
Yes, thank you, Chairwoman McGuire. Having spoken with some of the concerned entities earlier, they'd prefer to keep the 2 bills separate with regard to the licensing requirements for APRNs versus RNs, and have that introduced separately. So, given that, a motion to approve.
All right. Is there a second?
Ought to pass.
Representative Leon seconds. Okay, do you wish to speak to your motion?
No, I do not. Thank you.
Okay, Representative Leon?
Thank you, Madam Chair. It's the exact same language as the RN, so I think it should be pretty straightforward.
All right. Does anyone else have a comment, question, concern? I don't see any. All right, that case, the motion is ought to pass by Representative DeVries, and the clerk can call the roll. when ready.
Sleep at the switch. Vice Chairman Leon.
Yes.
Clerk votes yes. Representative Pearson.
Yes.
Representative Bailey.
Aye.
Representative Sheehan.
Yes.
Representative Schlotchi.
Yes.
Representative Grote.
Yes.
Representative Schmidt.
Yes.
Representative Davis.
Yes.
Representative Dargy.
Yes.
Representative Howard.
Yes.
Representative Reese.
Yes.
Representative the Chair.
Yes.
I think that's 13-0 again.
Okay. Okay, the motion passes 13-0. Is there any objection to consent? Okay, seeing none, we'll put that on consent. Representative Rees, a committee report at your earliest convenience. And back to Senate Bill 180. Does that need to go to subcommittee, Representative Sysak?
Look, your point, Chair's point, your point about how it actually gets implemented is, it's important, but this bill, I think it's important enough to go through. I don't see any real harm in the fact that it lacks implementation. What are we going, how exactly, are we going to give them a veto? Are we, exactly what do, I don't want to see this not go forward. Those stories are moving. It's important to actually see it in the flesh as opposed to this is just something. I'm prepared to vote for this warts and all.
All right, I interpret that as Representative Sytek moves ought to pass.
I'll move what to pass.
Is there a second?
I'll second that.
Okay,
Well, unaccustomed as I am.
yeah, well, that is very true, but Representative Pearson, do you wish to speak to your second?
I had the fortune of traveling to Milan during the eclipse, which was the only part of New Hampshire that was in totality for that event. I'd never been up there before, and you know, the idea that COAS is very different was glowingly obvious. And you know, I do see how in a lot of ways Coos County gets kind of left out. I mean, the county has less representatives than Derry. So I think that, you know, their economic situation up there and the unfortunate trends that continue in Coos, we've got to try something else. We've got to try something different to bounce them back. So is this going to be the be all end all? Probably not, but I think that it's going to assist them in trying to reinvent what Coos County looks like moving forward. So that's why I support 180 moving forward.
Any other comments? Representative Grote?
I hate to be the one to rain on everybody's parade here, but I'm fine with designating them as a distressed place-based economy because it helps them attain a special classification of grants. But I do get concerned because when we start talking about involving the counties and the state agencies, because that should be happening anyway between counties and state agencies. And to carve out something for it, I just don't know how this particular thing is not going to cause a complete, it's not going to cause issues between other counties who are going to say, well, let's just take my county, all right? The fishing industry in the seacoast. Why can't we, we enact legislation that affects that all the time. So why are we doing that? Why are we, but there's nobody from, and there's other areas in Rockingham County. There are areas in Hillsborough County. I mean, there's every single area of New Hampshire, because we are a rural state, has these issues. So I don't know how, I just don't, I'm concerned about that part of it. And I don't know how to wrap my head around how that's going to be helpful to them and not be considered, whatever you want to call it, preference by other counties.
Okay, Representative Pearson has the response.
I think in one way though, Rockingham County has 74 state reps. And Hillsborough County has even more than that. So the voices that are available for the problems that exist in the southern part of the state are much broader, much greater than the 9 that COAS gets. So I think that the attention that's drawn to the most, especially the 2 most populated counties, is undeniable in the way we do things in New Hampshire. And we can't, all children are not equal and all counties are not equal. And I don't know how we can do things at the state level without recognizing that there are some differentiations up there.
Okay, Representative Brody.
Our legislating system is based by population, so it's always going to be that way. But that doesn't mean that just because we live here, doesn't mean that we don't consider things about how they're going to affect up there. I mean, that doesn't make any sense. That analogy to me is not enough to push me to this.
Okay, Representative Leon.
Thank you, Madam Chair. I also agree that I don't have a problem with Section 2. I think that designating it as a distressed place-based economy and giving a better opportunity to compete for grants and whatnot, I think makes a lot of sense. I'm very concerned that frankly, the agency should already be talking to the county and the county commissioners. And now we put some strongly worded language in there, but there's no enforcement in this. I'm just very concerned that this is just going to create even more confusion and that this isn't actually going to do anything to help them in order to straighten out any of the challenges that they're having there. And further, if they have to be meeting with the county commissioners at one of their commission meetings, then you add in the delay, because you have to wait in order to bring something to them at their commissioners meeting. When we look in JELCAR at approving different rules, when we're dealing with something from a board, are they meeting on the same day as JELCAR? And so we need to then delay it another month so that we can have the input from the board on the rules that we're approving before it goes through JELCAR. If you look at those unintended consequences of legislatively stating how something needs to work in this interaction, that gets to be pretty complex. And I don't think that that's going to be as helpful in the long run if they're not working together in the first place without enforcement. I'd really rather see this Section 2 move forward with the rest of it removed and just have this come through in flying colors instead of talking about why we're going to put some language in that's entirely unenforceable when it should be happening in the first place.
Representative DeVries.
Thank you, Madam Chair. The enforcement piece gives me pause here. Some of the assumptions that are written into the bill are concerning to me, that it suggests that the state may be undermining revitalization investments, which I don't think is the case, although the state may not be helping. And with regard to forcing the state to have the county at the table when they're considering policies that may affect Coos County, whether it affects Rockingham or Hillsborough or Cheshire or Stratford, whether they want the same things. I think that it speaks to the fact that somebody's feeling like a redheaded stepchild here. And so I am in favor of this in general. but I would like to carve out the enforcement piece and forcing people to the table, even though I recognize it as a valid concern.
Representative Salachi?
I agree with Representative Grota Leon, in principle.
Okay. Representative Saitek?
My view is everybody's on the dance floor except the Coos County. And in my view, we're arguing about niceties, even if they're unenforceable, all of that. I think this is a message that we need to send. That county is bleeding and we're arguing about the color of the Band-Aids. I just am willing, I've said it.
Okay, I'm Representative Leon.
Thank you, Madam Chair. This is not said to be offensive to anybody who thinks that this would work, but it's almost like we're talking about praying over somebody with a massive hemorrhaging wound if we're saying that we're going to put some language that sounds really nice into statute without anything backing up. So I apologize to anybody who it sees prayer as a way to deal with a massive bleeding wound.
Okay, well, Representative Schmidt?
Okay, so the problems that have been articulated are mainly with the section that most people regard as unenforceable. But the other part of the bill is clearly something of a hand up for the people of Coos County. I have been up there and actually was up there recently, relatively recently in Whitefield. And if you've never been up to the North Country, you got to go up there sometime. It is fantastically beautiful. And I was the chairperson of the Stratford County delegation for a number of years. And I often thought about the reality that Coos County, which has about 31,000 people at the moment, I think, has fewer people than the city of Dover. Dover pays about 28% of the county costs in Stratford County, with 35,000. I think we are up pretty close to that now. Coos County pays for 2 nursing homes because it's so big that if you want to visit grandma, you can't be driving 2 hours in both directions for an opportunity to spend some time with a loved one. They have all the costs of the county. Do the per capita cost calculation sometime, what the citizens of Coos County pay for their county government vis-a-vis what they pay just in Stratford County. We pay 28%, as I said, of Stratford County costs. With comparable population, Coos County people pay the entire cost. So I think even if we have a portion of this bill that may be unenforceable, the other part is a hand up rather than kind of a shrug and not a slap in the face, but kind of like hold up your hand and say, I don't see the rest of the world because I have my hand over my eyes. So I'm going to be voting for this with a hope that we can do no worse. Thank you.
Well, I tend to agree with those who are concerned that it's got an unenforceable and very vague requirement laid on the state agencies. I don't know how it would be accomplished. If you look at the fiscal note, it may have changed a bit, but they're still talking millions of dollars to carve out Coos County, which I'm not sure I believe, but still, I think that the agencies need to consider specific applications throughout the state and not just one piece of it. And so I can't support this without an amendment. Since we all like the first part and we think we should declare COAS a place-based, distressed place-based economy, is there someone who would like to develop an amendment to take out the second part of the bill? Representative Sashi?
I was just going to comment that I would love to see an explicit exit date or a sunset date for that type of thing. So
That works too.
yeah, it'd be lovely.
Put it 10 or 20 years out. All right, so why don't you work on an amendment and we will resume this later, because I think it is important and a lot of people care about it, but I can't really support passing it as is.
You want me to withdraw my motion?
I just wanted to ask that because we have a motion and we have a second.
Yes.
So what do we do with those things?
We could
We
withdraw.
could
if
either
both-
withdraw or we could say, it's open for further amendment.
Why don't we just withdraw it and come back?
Okay, withdraw.
I'm willing to withdraw. Representative Pearson, okay, we withdraw our motions.
All right.
And we'll wait for the new improved, lightweight version.
Okay, go for it. All right, I don't think there's anything else we can do today, so we will be in tomorrow for the last of our Senate bills.
See how fast you can get your amendment done. 10 years sounds fine. You pick it.